Mentioning
origin side listed matters. Item number 1, Robindranath Mullik.
Lord, I am appearing for the petitioner in GA5, which has been especially assigned to my lord. My lord, GA5 is my application seeking restoration of the suit, my lord.
I am appearing on behalf of the subsequent purchaser. I am appearing on behalf of the subsequent purchaser. Intervener.
you are made party or you are yet to be made party? Yet to be made party.
No, my lord, I made party.
My lord,
You are made party.
They are not party to the suit.
How can he be a
But there was a direction of this court to serve a copy of the application, and
That's okay. What are the grounds?
My lord, Mr. Sumandat is leading me in this matter. Kindly fix a short date, my lord.
Any you?
We have pleadings are complete. Lordship keeps it in June.
My lord, so far as the intervener is concerned, I am filing my reply, my lord.
Reply to intervention application. That is not in the list, I think.
My lord, they have
Their affidavit to their application.
My lord, they were given right to file an opposition, and they have served a copy of the opposition to me, and against that, I'm filing a reply, my lord.
But that affidavit in reply,
It is not in yet.
no, that file on the next date. Let this be disposed of first. GA5 of 24 shall appear in the list on 18 June for hearing.
Item number 2 and 3.
My lord, I am appearing for the respondent number 1, my lord.
I appear for the respondent number 8. I beg to appear on behalf of the petitioner.
All appeared, summons was served.
But there was a direction for issuance of notice under Rule 24 of the Calcutta High Court election rules, my lord. Now, there will be a report, my lord, I understand, my lord, to be filed by the registrar original side. I find the ECI here, my lord. The return candidate, I understand, Mr. Anirban Rai is already representing, my lord.
I am for the respondent.
Yes, notice was served. Upon all.
I am for the respondent of 4, 6, 10, and 11.
I am for 8. Yes. All right.
Prior to lordship that I will take an application to relieve my name because election commissioner of India cannot be made a party to the.
He keeps on
File
making-
appropriate application, then I will hear it. The report of it is item number EPA number 5.
My lord. But my lord has passed similar orders, my lord, in other election matters, my lord. This will be of some aid, I understand, my lord. Nishita.
Yes. Report of the learned at EP 5 2024. The report of the learned register original site dated 2nd May 2025 be kept in record. The report shows that notices were sent to all the respondents and items were delivered. Full stop. The learned counsels appearing for, give you names.
Yes.
Whom you are representing.
Yes.
Appearing for the parties, please leave to file written statement. Full stop. Written statement shall be filed on or before the returnable date. The suit will appear, the application will appear in the list on 10 June.
Grateful to you.
That will not file agency.
That is his
But
discretion.
are at liberty to file written
Liberty.
statement. I'm not forcing you to file written statement. It's only a liberty. Whether you will contest or not, that's up to you. Similar order in item number 6. keeping on the same date.
Grateful to your lordship. In that matter, my lord, I am not there, my lord. Item 6, item 3, someone else will be there, my lord. I am not appearing in item 3.
EP6,
EP6.
you are for?
Petitioner, I would like to file a supplementary affidavit with this matter. Stating some report of facts.
Then you have to amend the application itself, not supplementary.
It's not this. I would
If
like
you are- want to-
additional documents
If you want to additional documents,
by way of supplementary.
you want to disclose further documents.
Yes, yes.
That's your liberty. You file appropriate application, not you have to file application. Praying for leave, not supplementary affidavit. This is not application hearing.
Grateful to your lordship. With your lordship's leave.
ওখানে লিখুন ছয় লিখুন EP number 6, Mr. Bosch, the learned counsel for the petitioner submitted that some additional documents.
Mr. Who have
Mr. Sorry. Forgot your name. Mr. Gohagorota, appearing for the petitioner, please leave to file additional documents. Leave is granted to file appropriate application. Report of the next para, report of the landed register original site shows that summon notices were served upon all the respondents. Written statement, liberty is given to file written statement on or before the returnable date. The application will appear in the list on আগেরটা কবে বললাম 10 June. Mr. Gohagorota, I think you should take care of your hair. It should have a uniform color.
Item number 4 and 5.
Yes.
4 and 5, I appear not for the substituted defendants, not number 1, not this matter not has been settled between the parties, not we are filing not the compromise terms not signed by the parties.
In both.
In both the matter,
both,
my lord,
both,
we
yes.
pray for a decree pursuant to the terms of settlement.
Then
Consent
separate orders are there. Separate
Yes, two
terms of
separate
settlement.
separate order pursuant to clause
Suit will be withdrawn.
5.
Should be
Dispose of
It will be disposed of.
pursuant to these terms of settlement, the decree we are praying for.
There will be decree in terms of the terms of
Point
settlement.
number 5, my lord.
No, there will be decree in terms of the terms of settlement.
There will be a decree in terms of the terms of settlement. Point number 5.
So the suit was against the father, my lord. The father expired, no, the son has taken the responsibility, my lord, to make payment.
Now you have to follow the terms of settlement.
Yes,
My lord.
decree as
But
per the terms of settlement.
No, the decree cannot be drawn up right now. Because one of the terms is name of the defendant number 1 and 1A and 1C shall be deleted. Then this exercise shall be done first. Otherwise, how decree can be drawn up?
My lord, the decree, my lord, will be drawn up, my lord, as per this, my lord. There is no difficulty, my lord. This your lordship passes decree as per the terms of settlement, but the department, my lord, will delete their name while drawing up the decree. So this has happened earlier also, my lord. I don't think there's any difficulty.
Compromise decree. Sorry. এটা একটা সুটে লিখবে CS 82. Learned counsels files terms of settlement dated 28/4/2025. Let the suit be decreed on compromise. Name of the defendant number 1A and 1C shall be deleted from the cause title of
Very
the
good.
suit.
No, this will solve all problems.
Hmm?
Yes, no, this will solve all problems.
Yes. This settlement shall be part of the compromise decree. Let this suit be disposed of.
My lord,
Same order?
yes, my lord. Both matters.
Both.
My lord, just one leave, my lord. My lord, to have the terms, my lord, stamp punched in course of the day, my lord. To have the not. Lord, liberty, my lord, to draw up the my lord, to my lord, have this terms of settlement stamp punched in course of the day, my lord. We'll just put the stamp, my lord, in course.
Then do one thing. Come tomorrow.
my lord, the corrected matter, my lord, is before the NCLT today, my lord. So it has to be done today. But we'll do it in course of the day. My lord, the order will be subject to the stamp punch. There's no difficulty.
The order will be subject to this stamp
Yes, my lord.
punch.
We'll do it in course of the day. Lordship may take it from me.
The instant suits are accordingly disposed of.
Item number 6.
I'm for the plaintiff, your lordship. My lord, I
What is
apologize.
GA1?
Number 6.
Lord,
Defendant number 6.
What is GA1?
Lord, before anything, your lordship, my lord may be aware, my lord, that fire broke out in Temple Chambers, your lordship. Lord,
Yes.
things are yet to be restored, your lordship. If my lord kindly post this matter after vacation, your lordship, we will do
You
the
are?
formalities. I'm for the plaintiff, your lordship.
On prayer of the learned counsel for the plaintiff, framing of issues is adjourned to 28 June.
Grateful to your lordship.
Item 7. Item number 7.
In this matter, I appear for the defendant numbers 2 and 4. Lordship, the defendant number 4 had passed away in 2024. I have sent the details of the legal heirs to my learned friend.
Substitution is to be done.
I'm for the plaintiff substitution. We had said, my lord. Only thing, my lord, the substituted heirs, they are already defendants in the suit. So all that will be required, my lord, only deletion of the name of the defendant number 4.
Have you filed any
Can
My lord, I
application
have to
that
take that
needs to be
formal
done, my lord.
application. You have
after
to-
vacation?
Yes, my lord. Only an application for deletion of the
I've
name.
heard it extensively.
Yes, my lord. Your lordship has heard this matter extensively.
The major issue is whether the company can be
Order 7,
partitioned.
Rule 11 application.
Yes.
Their case was that it's barred under section 430. The suit is barred under section 430. The defendant has made out that case, my lord.
Adjourned to, on prayer of the learned counsel for the plaintiff, the suit is adjourned to 19 June.
Suit is otherwise, my lord, not in proper order. Only the name has to be deleted, nothing else.
Item number 8.
I am appearing for the petitioner defendant.
What is GA3?
That is my application for rejection of the plaint. And I am appearing for the defendant numbers 15 to 20. My lord,
Who are you other side?
I am for the plaintiff.
Exchange of affidavit is done?
Yes, my lord. My lord would recollect on the last occasion, I am led by Mr. Shuddhashatta Banerjee. On the last occasion, he had started making his arguments. My lord, he was indicating from the application, it had fell from my lord, what are the grounds on the basis of which this application has been filed. My lord, will kindly take up paragraph 6 of my application, my lord. That is at page 19, my lord. My lord, the primary grounds is with regard to the fact that, my lord, 6, my lord, will see primarily, my lord, it relates to a deed of gift which was executed on 1st of August 1948. My lord, there has been no cause of action which has been pleaded in relation to this particular document. My lord, I am led by Mr. Banerjee, my lord.
Yes, Mr. Banerjee.
No, Lordship, we'll just have a look at the plaint once.
Now let me see the ground first.
Yes.
You know?
Paragraph 6, your lordship will find the ground.
Yes. Yes.
Kindly have a look at the plaint and the prayers once more.
Plaint is in page.
No, it's not annexed, my lord.
It is not
We'll
annexed.
find the plaint separately.
Yes.
But before that, I'll just indicate the plaint case. D26 claims to have purchased the property from one Aparna Singh in 2005.
Let me hear you first.
Yes. D26 has sold the plaintiff this property in 2011. Charubala Devi is stated to be the owner. There's a will, there's a probate in 1990. On the basis of that, there's a sale by Charubala Devi's heirs to D26 in 2005. D26 has sold the property to the plaintiff in 2011. In this context, please have a look at page 50, the praise in the plaint.
Page 50 of the plaint.
Yes. These are the praise. I'll just show the praise and highlight the plain frivolity of the suit. Declaration that the alleged gift deed dated 1st August 1948 is a false, fabricated and manufactured document and is the result of a fraud perpetrated on the said Charubala Singh Dev at Charubala Devi. Now, Charubala Devi is stated to be the owner in the plaint, and Charubala Devi or her legal heirs in her lifetime has never questioned this transaction. In the lifetime of Charubala Devi, this deed was never questioned. Kindly turn over, my lord. Declaration that all documents referred to in the plaint, which are more fully and particularly referred to in Schedule B to the plaint, purporting to transfer title or create an interest in the suit premises or any part or portion thereof on the strength of the alleged deed of gift dated 1st August 1948 are also false, fabricated, manufactured, and in any event could not have and have not transferred any title or created any interest in the suit premises or any part or portion thereof. Then decree directing delivery upon cancellation of the alleged deed of gift dated 1st August 1948. This Schedule B, your lordship will find at page 55. Now, kindly have a look at what your lordship has been asked to deliver up and cancel.
55 of the plaint.
55 of the plaint. So first is that the deed of gift to which the plaintiff is not a party, which during the lifetime of Charubala Devi was never assailed, never questioned, that 1948 deed of gift, your lordship will have to declare as void. And all these documents mentioned in Schedule B at page 55, delivery upon cancellation and declaration, these are also void there. Please have a look at what these documents are. The Schedule B, the documents immediately under Schedule B, the documents purporting to transfer title or create an interest in the suit premises on a part or portion thereof on the strength of the alleged deed of gift dated 1st August 1948. Registered deed of conveyance.
Just a minute.
Dated 24 July 1975. Executed between X and Vikramaditya Prasad Singh Dev and Udatya Prasad Singh Dev on the other part, registered in the office of so and so. Lease deed dated 11 September 1984, executed by Vikramaditya Prasad. Next, agreement for sale by Bhuvaneshwari Prasad Singh Dev with Bimal Kumar Jhajaria. Next, conveyance dated 24th August 1981, executed by the learned registrar of the Honorable Court at Calcutta in favor of Bimal Kumar Jhajaria. Will made by Bhuvaneshwari Prasad Singh Dev in favor of Ranjit Prasad Singh Dev. Letters of administration obtained by Maheshwari Devi in respect of PLA number so and so. Order dated serial number 7. Order dated 24th July 1998 in PLA granting leave to Maheshwari Devi to sell the movable properties of the estate of Durgesh Kumar Devi on 18 January 1990. Memorandum of Understanding of 21st of August 1992 by and between Maheshwari Devi and Vanisha. So your lordship will have to set aside registered deeds of conveyances, orders passed by this honorable court, a will, letters of administration, another order by which a receiver was directed or allowed to sell the property being sold after that. So what has happened is he claims title from Charubala Singh, I forget the name.
Charubala Singh Dev.
Charubala Devi.
Charubala Singh Dev alias Devi.
Yes. Charubala Devi, and yes. And claims that the property was sold to X 26 in 2005. Now, this property that is sold in 2005 is sold to D26. D26 sells it to him in 2011. In the interregnum, Schedule B at least highlights 8 such documents, which in the meantime, the property is already changed hands. It's been sold. These are registered deeds of conveyances. I want to assail this on just a reading of the plaint on 3 counts. One is a will or a probate or letters of administration are granted under the, that is a code by itself.
Loving of 2 jurisdictions.
That's one. Firstly, this is ex facie prohibited by law. You have to go under
revocation.
That's right. You can't have a separate suit asking for that. The second ground is that if you are not apart from it being ex facie barred by limitation, once Charubala Devi or her so-called legal heirs or predecessors in interest have not assailed the document, then somebody else later can't come and assail that document.
Third party.
Third party.
But these are more question of fact.
This is absolutely just on the law. I'll cite one Supreme Court decision where similar facts were there, where a fictitious cause of action has been created and a fictional date has been given in that judgment also to say that on this day the cause of action has arisen. Once there is a registered deed of conveyance, which is Schedule B, serial number 1, dated 24 July 1975, a registered deed of conveyance coming from Section 3 of the Transfer of Property Act is stated to be or known to be notice to the world at large. It's deemed to be given notice to people who are interested or has any interest in the property. It's constructive notice, and if you've not taken any steps, then it's called willful abstention. If there is willful abstention of the person who has the right to assail the document and has not assailed the document, then that person allowing the document to survive, then in her lifetime, after the period of limitation has expired, successors in interest cannot claim any interest or cannot assail the document also. And here your lordship will see first document that your lordship being asked to set aside is the deed, a registered deed of gift of 1948, which Charubala Singh Dev or Devi has not assailed in her lifetime. There's a registered deed of conveyance of 1975. This is also not there. I'll have to place the plaint to show how he has traced his title and how he stated how I have acquired title in the property. And in stating while I've acquired title in the property, he asked for delivery upon cancellation of all these documents, which are registered documents from 1975. 2 aspects, your lordship will consider, where in the lifetime of Charubala Devi, she does not do it. That is one point. Secondly, it is stated that I am in possession, even if I am not in possession. With the pleadings in the plaint, I argue on the basis of Section 27 of the Limitation Act, that Section 27, Limitation Act being a statute of repose, Section 27 is just one of those sections which not only bars the remedy, it also extinguishes the right. This is the unique provision under the Limitation Act. Your lordship would be aware, my lord, that kindly have a look at the Limitation Act, Section 27. This is not one provision which just bars the remedy. Section 27 extinguishes the right also. So if steps have not been taken for recovery of possession within the period of limitation prescribed under the articles, then not only does the remedy go, it extinguishes the right. That all these points have been captured in one recent Supreme Court decision of 2024. I'll just cite that. If your lordship has a look at 27 once, at the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. As opposed to other provisions, or how we've understood, at least how I understood the Limitation Act to be, that being a statute of repose, it keeps the remedy, keeps the right, curtails the remedy. 27 is one provision which finishes off the right itself. So in the lifetime of these persons, when the property has changed hands and somebody else is in possession, the failure of Charubala Devi or her successors in interest who have allowed these documents to remain and not been in possession of the property, then their right itself stands extinguished. And if their right stands extinguished, there was no right that the succession interest had to pass it on to somebody else. Well, the other very oft used nemo dat quod non habet. What I don't have, I can't give. So if I don't have that right, I can't give it to you. If my right stands extinguished by law, then in 2005 D26 and 2011 coming to me, the plaintiff, is not something that can be countenanced in law. It's just an issue of law. And not just being ex facie barred by limitation. This is a point slightly deeper than that. I'm not saying reading of the plaint ex facie, because you lordship will hear this as a very hackneyed, standard, legal, but standard hackneyed argument that look, prima facie existence, that's the law. But this is slightly different. I am not attacking it on the point of limitation, cause of action. I'm not saying that. I'm assailing it on a different point here. I am saying that in the lifetime of a person, if you have not challenged the document and you've allowed that document to remain, a document that is a registered document, then your right stands extinguished. It's barred. Once your right stands barred, you have no further right to give to somebody else. Then, and in this case, it's Charubala Devi, D26, Charubala Devi, D26 to Aparna Singh, then D26.
How many defendants are there?
Many. 26 or 28 defendants. 26, I think. 28 defendants.
26.
Here, your lordship will find 26.
Kailash Devan.
Kailash Devan. And the plaint also makes a very unique read, because they had to cover up why they were coming up in 2016 to assail deeds of 1948. Because your lordship, his substratum of right is this deed of gift. Why? Because this Charubala Singh has executed the deed of gift in 1948 or 1942, whenever. And there are two aspects. When your lordship is looking at a document, if fraud is pleaded, there are two types of fraud apropos a document. One is the document itself is fraudulent. The other is that the purport I don't know. So the law treats these two aspects of fraud in relation to a document differently. One is I don't know what the document itself is. I am signing a deed of gift, thinking it's a memorandum of understanding. That's one aspect of fraud in relation to a document. One is I know it's a deed of gift, but in that deed of gift, you've written something that I don't know. So fraud in respect of the first set is of a far higher degree than fraud in respect of the second set of allegation. Here, somehow, first set, second set, Charubala has not come forward ever. And Charubala's deed from 1942, which is why your lordship is having to set aside, or they've called upon this court to set aside all these documents, because from 1975, the property has changed hands. It's been sold through a receiver of this honorable court. It's been sold pursuant to a letters of administration. The entire transaction is there. And he's pleaded that in the plaint. I will have to plead the plaint, and I'll cite one judgment. And I think it covers this entire issue. Mine is also borrowed intelligence from this recent 2024 judgment which has come out. I'll just cite that. Justice Pardiwala's judgment, but your lordship will have a look at the plaint once. 2020. I don't cite points. I don't cite it. জানি আরেকটা সুপ্রিম কোর্ট, দুটো সুপ্রিম কোর্ট পাঠাবে। May I just place the plaint once? Paragraph 2 onwards, your lordship will see. And it's a shortish plaint. I'll just show how the title is traced. Defendant number 1 is the daughter of one Durgesh Kumari Devi or Durgeshwari Singh Deo since deceased and has been granted letters of administration in respect of her estate. The defendant number 2 is a company Defendant number 2 purports to have entered into a memorandum of understanding with the defendant number 1 for purchase of premises 2/1 Loudon Street. Defendant numbers 3 to 7 are legal heirs of one Vikramaditya Prasad Singh Deo, who and defendant number 8 are jointly alleged to have acquired a part of the suit premises from one Marilinda Bernadette Fitzgerald and her 4 sons, that is the wife and 4 sons of Bhubanesh. Well, from here it gets very interesting. Bhubaneshwari Prasad Singh Deo since deceased. Bhubaneshwari Prasad Singh Deo.
Just a minute.
Yes, ma'am. Paragraph 5. Bhubaneshwari Prasad Singh Deo allegedly entered into an agreement with the defendant number 9 for sale of a 8-kata portion of the suit premises to him. The defendant number 9 filed a suit being CS number 381 of 1973 in this honorable court for specific performance of the said alleged agreement against Durgesh Kumari Devi as the mother of Bhubaneshwari Prasad Singh Deo, Marilinda Bernadette Fitzgerald as the wife, and against her 4 minor sons. Although written statements were filed in the said suit by both Durgesh Kumari and Marilinda, and a voluntary statement was filed in the same on behalf of her 4 minor sons, the said Marilinda or her minor sons did not ultimately contest the same. In the circumstances while decreeing the suit on 11th August 1978, this honorable court was pleased to hold that it would, in the peculiar circumstances, be sufficient if Durgesh Kumari executed and registered the conveyance of 8-kata portion of the suit premises in favor of defendant number 9, pursuant to and in terms of the said decree. On 24th August 1981, a conveyance of the 8-kata portion of the suit premises was executed and registered by the learned registrar of this honorable court on behalf of Durgesh Kumari in favor of defendant number 9. Defendant numbers 10 to 14 are the wives, sons, and daughters of one Ranjit Prasad Singh Deo since deceased, who are claiming ownership of the suit premises on the basis of a bequest made by Bhubaneshwari Prasad in favor of Ranjit Prasad Singh Deo by a will. This will has also, your lordship, has been given this arduous task of setting this will aside also. Defendant numbers 15 to 20 are the legal heirs and are the heirs and legal representative of Banwari Lal Sharma since deceased. They claim to be lessees of a portion of the suit premises on the strength of a registered deed of lease of such portion that was allegedly executed by the said Vikramaditya Prasad Singh Deo and the defendant number 8 in favor of Banwari Lal Sharma and in favor of defendant numbers 21 to 23. The defendant numbers 21 to 23 are such, claiming to be lessees of the said portion of the suit premises. Defendant number 24 is claiming to be a lessee of a portion of the suit premises on the basis of a lease allegedly executed by one Jagodishwari Prasad Singh Deo, the father of Vikramaditya Prasad Singh Deo, and the defendant number 8. The defendant number 25 is claiming to be entitled to a flat, being flat number 4 on the first.
You show me that part of the plaint which pinches you.
Whole thing. The whole thing. Well, this is one. I can't identify the portion of the shoe that pinches me. The shoe itself is a pinch. This is unimaginable, my lord. If your lordship has seen from paragraph 5 to 9 and onwards, this whole shoe pinches. It's hilarious to a point that somebody's come and filed a suit like this. And because it's so hilarious, they don't take any steps in regard to this suit till, I think, summons was served when? 2023. Suit is of 2016. Because they just did not know after filing, they prepared it. But after filing, how do they go about a suit like this? If your lordship looks at just the praise and the schedule B to the plaint, it's evident that the properties changed hands through at least 8 different documents. And the substratum of his right is the deed of gift. That deed of gift, your lordship will kindly see how it's pleaded.
Paragraph?
11. The fact, however, is the Charubala Singh Deo, who was the undisputed owner of the suit premises, died leaving behind a will dated 6 September 1985, whereby and whereunder she bequeathed the said suit premises in favor of her daughter Aparna Singh. Since deceased, Aparna Singh, who was also the executrix of the said will, obtained probate of the same from the City Civil Court at Calcutta on 25th October 1990. Thereafter, by a registered deed of conveyance dated 15 July 2005, she sold the suit premises to the defendant number 26, who in turn sold the same to the plaintiff by a registered deed of conveyance on 8th of March 2011.
All right. If you need, you file a short notes of argument.
No, just on these facts, I'll just highlight how he's traced the title and this relation to the gift.
Only thing you have to show that these are though they are question of fact, but there are more elements to consider rejection of plaint.
That's right. I'll just cite this one judgment. Identical facts had come up.
Come
There
with
were
the notes
orders
of
passed by
argument.
court and there were registered documents. Once the document is registered, it's notice to the world at large. Section 3. Once it's notice to the world at large, if you've not challenged it in a lifetime, then irrespective of what you've done. Let's say today I have done a gift and given it to him. It's a gift by which he has acquired title. Then I make a will and give it to him. And that will gets, and then he goes ahead and sells it. That by then the property is gone. Which is why now he's coming up and telling your lordship that this deed of gift by that I have given to him, this should be cancelled. So what has happened is by a gift, I have given it to him. Later, I have made a will and given it to X. X becomes the executrix, gets the probate, then transfers it to Y. Y sells it to him. He comes now to court and says this deed of gift must go. Because if this deed of gift is there, he has no right.
Come with the notes of argument and judgments.
Yes, I'll do that. But I'm otherwise ready with the decision. I'll come back with the notes and
short note.
Yes, just on this point. There is nothing else that I really need to.
Hard in part adjourned to 19 pay.
I need to.
19th is okay or any other date?
Great.
Item number 9.
For the plaintiff, Lordship.
Discoveries inspections are done.
Lordship, the commissioner's report of the special referee has been filed. We have preferred an exemption. We have preferred the exception already. They are yet to file.
For main profit.
Lordship, not
claim counterclaim.
Claim counterclaim.
I'm paying for some type of filing exception.
What special referee is doing?
Personal order.
The report has been filed by him.
What special referee is doing? For why he was appointed?
There's a compromise between the parties, my lord. There's a compromise. Their claim was 6 crores, out of which 3 crores are deposited in the court registered with the original side. By an order, they would do the money and hand over the possession. And thereafter, the matter report was appointed to adjudicate the dispute between the parties. After taking evidence, he signed this report. And last year, pleased to pass an order on the last occasion, directed me file an exemption, but due to unknown circumstances, I'm taking some time because my client is sick, my lord. I can't afford the evidence, my lord.
Time is extended to file exception on prayer of the learned counsel for the defendant. The suit will appear in the list on 18 June. Exception shall be filed on or before the returnable date.
Ten, 11. Item number 10 and 11.
My lord, in item number 10 and 11, I'm appearing for a plaintiff, my lord. On the last occasion, the amendment application was filed and this court was pleased to allow the amendment application. We have reaffirmed and re-verified the plaint, my lord. But my lord, there is paying for a direction to service upon the directly, my lord, the respondent, because the advocate is not appearing in this matter for last 2 or 3 years, my lord. Even in amendment application, my lord had given 2 or 3 opportunity, but
none appears for the defendant. The learned counsel for the plaintiff. Is directed to serve the copy of the amended plaint. to the registered address of the defendants. Let this suit appear in the list for further direction on 24 June.
For the plaint.
What is J10?
But my application, I'm already enjoying an interim order. I'm asking for confirmation of the interim order after affidavits. Well, here, what has happened?
Injunction order.
Injunction order.
I take you appear on just the defendant number 1.
Well, I'll tell you.
I have got the defendant number 4.
I'll tell you, Lordship, what has happened, my lord. Well, there's a 38 kattha property in Pretoria Street. The property is, as of now, divided into two parts. One is a 30 kattha and another is a 8 kattha. Today, we are concerned, my lord, with the 8 kattha, which is 6B Pretoria Street. The 30 kattha property is 6A Pretoria Street. My lord, I am the owner of the property. My father, before me, had executed a deed of lease in 1971 for a period of 62 years, which comes to an end.
Exchange of affidavit is complete in J10?
Complete. My father had executed a deed of lease in favor of the defendant number 1 in respect of the entire property for a period of 62 years, which comes to an end in 2033. The defendant number 1 had executed a sublease and given this property and sublease to the defendant number 4 for a period of 55 years, and the lease coming to an end on 31st March 2028. Subsequently, there are other disputes which have arisen, primarily with the defendant number 1 and defendant number 2 and 3, where my case is that taking advantage of me and also coercing me and in various other undue influence, the defendant number 1, in collusion with the defendant number 2 and 3, have caused to execute a 99-year lease in respect of the 30 kattha property, that's 6A, by which the property has gone and I have received only 16 odd lakhs. The property is one of the 30 kattha property on Pretoria Street. Taking advantage, if your lordship sees that deed of 2017, your lordship will find that the consideration is shown as 14 crores. 7 crores, 7 crores and another 16 odd lakhs. 7 crores and 14 crores, the defendant number 1 takes from the defendant number 2 and 3 and gives me only 16 odd lakhs. So for 16 lakhs, a 30 kattha property has been given for 99 years by hoodwinking me. So that was my primary cause of action. When I filed that suit, my lord, I have also challenged the 1971 lease which my father had granted, because that was a lease without possession. Your lordship knows, my lord, if a lease is granted without possession, my lord, then the lease is bad. So taking all these points, my lord, I had challenged the 1971 lease which my father had given, the subsequent lease, the sublease which has been granted, and also the 2017 lease regarding the 30 kattha property. There's an order which was passed with regard to the 30 kattha. No parties will deal with the property. Now, my lord, this was all in 2020 when the suit was filed in 2020.
30 kattha means 6B.
6A.
6A.
6A. This is, my lord, when the suit was filed in 2018. Now, my lord, when the written statements have been exchanged, well, after the written statements have been exchanged, subsequently, my lord, the defendant number 4, defendant number 4 had filed an application to bring out new documents and also for bring out new documents. In that application, the defendant number 4 has made out a specific case. I would just want to read out that one paragraph for your lordship. If lordship takes my application.
You are referring to paragraph?
I'll just, lordship, just give me one moment. Lordship takes page 196 of my application. Page 196. Your lordship will remember, the defendant number 1 has subleased the property till 2028, the 8 kattha. Now, the defendant number 4, in that application, paragraph 12, says, moreover, very recently, the defendant number 1 has approached this defendant that he is likely to give an extension of the period of sublease in favor of this defendant, for which negotiations are going on. So when I come to know that the 8 Kattha 6B, that is also going to be dealt with. Then, my lord, because my lord, it's a case which has been made out by the defendant number 4 itself. So I come before this court that till my suit is heard out, whether I have a right, wrong, or whatever, the sublease is challenged, the initial lease is challenged with regard to the 8 Kattha property, no sublease should be granted. In any event, my lord, till 2028, the lease is very much there, sublease is there. There's no requirement of executing a
But that
sublease.
cause of action is yet to be mature.
My lord, but the statement is that they will deal. Your lordship will see. They are not denying by this point. They are saying, my lord, that today they will execute an extension which will be from 2028 onwards. But why should it be done at all at this point of time? It is their case. The till, my lord.
Property is yours and they are making money.
Yes, my lord.
That is your point.
My point. So as of today, the trial is going on. My lord, the witness is before your lordship. My lord, the witness has been coming, my lord, and the defendant number 1 is cross-examining the plaintiff's witness.
So what is your prayer right now?
My prayer right now, my lord, the ad interim order which your lordship has granted. My lord,
Where is that interim order?
January 2025. Yeah, sir. 15th January. That this party shall maintain status quo as regards title, possession, and nature of the suit property, especially 6A. It should be 6B. It was corrected later, my lord. On 21st January, it was corrected.
So 15 January and 21st January shall be read together.
Read together. So as of today, my lord, I am seeking, my lord, and they are not disputing in their affidavit in opposition also. They are not disputing this fact that they are going to deal, they are going to execute. Just by saying it is premature, that means let them execute, then I will come before this honorable court. It is their case on affidavit that they are going to deal with the property.
Yes.
So your lordship sees their affidavit in opposition, my lord, which they have filed. They have not at any point disputed that they are not going to execute the extended deed of lease. There is no statement to that effect, my lord, by the defendant number 1 or the defendant number 4. And I am showing, my lord, on affidavit, the defendant number 4 itself has made out a case, negotiations are going on, and that they will execute a extended lease, which will be from 2028 onwards. There is no requirement of it at all right now.
When this lease will expire?
28.
Where it is stated?
My lord, your lordship will see.
Where it is in your application?
I will show, my lord, I will show. My lord, if your lordship takes page 159.
No, in your application itself.
In my application also I've said, my lord.
There must be some amendments.
Yes, my lord. Amendments are there. The pleading, my lordship takes my lord paragraph 63 at page 30. 63, 64, 65. Page 30. And in their own written statement, they have said that it's till 2028. That your lordship will find, my lord, from page. Your lordship takes.
Yes, I got it.
Yes, my lord. In their affidavit in opposition also, they are saying it's till 2028. There is no dispute regarding that. These expires, my lord, as of now, 31st March 2028. This case they have made out in paragraph 4G, page 19 of the AO of defendant number 1. They have also not disputed this fact. And in my suit, if your lordship just takes my prayers in the suit,
Yes,
your
sir.
lord.
Yes, this is also in the application.
Yes, ma'am.
AO also.
AO also it is there. AO also. They are not disputing this fact. Now, if your lordship now only takes, my lord, one page 26 of my petition, para 56, these are my prayers in the suit. Volume 1, page 26.
Yes.
Para 56, under the suit prayers, prayer A, decree for declaration that the instrument dated 3rd March 1971, rectified on 26th April 1971. This is the original lease which the plaintiff's father had granted to the defendant number 1. That is also under challenge. So defendant number 1's right in the property itself is also under challenge. What the defendant number 1 has done on 14th December 1973, this is the sublease. It should have been 19. 14 is my by mistake. I think it should be 19th December 1973. Annexure G. This is the sublease which was granted till 2028. That is also under challenge in the suit. So as of today, there is no requirement whatsoever of extending the lease.
All right.
Well, this is my. I'm obliged.
I'm taking your AO first. This is AO by defendant number 1.
May I have your lordship leave? I'll come back, my lord.
Kindly be pleased to take the plaint once. But I'm taking my lord's leave. I need to show your lordship the averments made in the plaint. It's a little longish, but this needs to be brought to your lordship's notice. Property is entirely at measures at 38 kata.
6B.
6.
Okay.
If we go a step backward, property was numbered as 6 Pretoria Street. 38 kata. 71 lease for the entire property. Good, bad, indifferent.
To whom?
To me.
71 lease to you.
By the plaintiff's father to me. Now, that 38 kata 6, my lord, later on, it was divided into two premises at the instant and the Kolkata Municipal Corporation. My lord identified two properties as 6A 30 kata 29 point something and 6B, which is the subject matter of this application. So far as 6A is concerned, my learned friend says that in 2017, by hoodwinking or undue influence or misrepresentation, I got the lease renewed for another 99 years at a peanuts of consideration. And so it's following the doctrine of proportionality. These
In 1971 lease was for?
It was valid till 1953. For 62 years. এটা তো এই property for up to 2033. 28 February 2033. My lord, may be pleased to find the tenure at page 124 of the application.
Now let me see the plaint itself.
My lord. My lord, may I read for your lordship? May I read for your lordship? My lord, up to paragraph 3, the plaintiff says how his father acquired the property. Paragraph 4, his father was suffering from financial difficulties.
Yes, that I've seen.
Yes. Paragraph 7, after his father died, the plaintiff had no option but to familiarize himself to the extent his intellect would permit with the affairs of the estate which comprised of the said premises.
The
and
institution of title is not clear here. You said in 1971, a lease was given for
62 years. The lease deed says 62 years. And one other property being, which is not the subject matter of this suit, which is also tenanted property. Before that, the plaintiff used to sign documents that his father asked him to sign without being apprised with the contents thereof.
where this case is made out. In 1971, such a long-term lease was given. Where is that paragraph? '71 lease was for 6 only.
Was for the entire 6.
6, that is 6.
Yes.
6 was gifted.
6 was
that is in para 9.
Para 9.
The 1971 lease, where this is stated. Now, how 6 becomes 6A is not clear.
This is also not clear, but from the plaint, your lordship may.
Have you stated in your WS?
My lord, I'll come to the WS. My lord, if your lordship kindly permit me.
My application, lordship, at page 22, my application.
Not in plaint itself.
Yes, my lord. The averments of the plaint are there, my lord.
But it's not in plaint.
My lord, it has to be there in the plaint because, my lord, we've produced the paragraphs from the plaint in my
Where it is there?
No, that
I'm not able to find.
Page 22, lordship.
Paragraph?
44, page 22. But we've explained how, my lord, the 6 Pretoria was divided into 6A and 6B. My lord, the plaintiff has averred that petitioner could not ascertain in spite of request of us, but it has been done at the behest of the respondent number 1. Because, my lord, it was done after the original lease of 1971. And at that point, my lord, my father and the respondent number 1 were aware of the affairs. I came into the picture only in 2002, my lord, when the gift deed 2000, in the year 2000. And this was all prior to that. 30th August 2002, my lord, this instrument is the extension of the original lease deed. 1971 lease deed was for 62 years, my lord. It was to end in 2033. And 30th August 2022, my lord, is the extension.
Area was 38 kota.
38 kota.
Entire.
Enter was 38 kata.
Yes, my lord.
That was divided into 6A and 6B. Now, my lord, 6A continued to be with the respondent number 1. 6B, 8 katas, that was subleased to respondent number 4.
Let me read the plaint. Let me study the plaint.
My lord, I am grateful to your lordship. My lord, only the first ground of my submission, first limb of my submission would be, it's a misjoinder of cause of action. Why I say so, and that is why I was attracting your lordship to this plaint. The plaintiff has assailed my 2017 action. that I only paid him 16 and odd rupees or 50 lakhs rupees for 30 kata property and got 99 years renewal. His case is it's disproportion. He was misrepresented, undue influence, etc. While doing so, he has also sought for cancellation of the lease deed of 1971, which also comprised of the property or now identified as 6B. That property, that lease was executed by his father. They have acted upon. It is not only his father who passed away in 2011, but also the plaintiff himself accepted the rent and they have acted upon. Now, since I cannot ask for partial rejection of the plaint, what he has done by way of misjoinder of cause of action, the plaintiff has included and also claimed for cancellation of that 1971 lease deed, so far as 6B is concerned, which cannot be permitted by your lordship.
We are hearing injunction application, not rejection.
Now, if he cannot succeed in the suit, the injunction is in the aid of the main relief. If he cannot succeed in the suit ultimately, if my lord is pleased to find that he cannot succeed in the suit ultimately with regard to 6B, he cannot get an order of injunction here with regard to 6B. I'm absolutely grateful that my lord has decided to look into the plaint. My lord, kindly look into the plaint, and then I'll place my case.
Because everything transfers from the plaint.
Yes, I'll rely on the plaint only.
Who are the other defendants?
Numbers 2 and 3. Lord, with regards to 71 lease also, Lord, I don't want to advance a sufficient today, but the 71 lease cannot be challenged in this suit. With regards to the injunction,
No, so far as injunction is concerned.
so it's with regards to a property in which I am not in occupation, and the other portions I am in occupation, for which will the suit will proceed.
You are in 6A.
I'm in 6A. And I am in 6A. It's defendant number 4.
Hard in part adjourned to before vacation or after vacation?
As your lordship pleases.
The suit is already there on the 15th. We'll process.
15th May.
15th May.
That is evidence is good.
13th May.
My lord, after the cross examination.
Not 13th.
Then after vacation.
After the cross examination, any day before vacation, subject to my lord's convenience.
Because it may not be concluded. Hearing may not be concluded on single day, possibly.
My lord, since my lord has already decided to go to the plaint, my lord, then it will not take much time.
Twentieth May.
Grateful, my lord.
Well, the interim order be extended.
Interim order be extended. Interim order was passed on.
15th of January of 2025. Thereafter, it has been extended.
My lord, corrected on 21st January.
Yes. Last extension was on 10th of April.
Interim order is extended till 20th May.
Good.
চেম্বার দিয়ে দেবে।
Item 13.
Item number 13, I am for the defendant number 2, 3, and 4.
Who is the plaintiff? আগের order কি আছে দেখি?
My lord, in the previous occasion, my lord was pleased to direct me to file Vakalatnama on behalf of 2, 3, and 4.
None appears for the plaintiffs, although learned counsel for the defendants are present. Adjourned to 25th June.
Item 14.
অর্ডারটা দেখি জিএ কম। What is GA Com 3?
No, no, yes, the GA3 in which we filed a supplementary affidavit showing.
May I have the request of
Just
indulgence?
a minute. GA Com, let me see GA Com because number is to be changed. It is not a commercial suit.
Yes, Lordship.
GA Com is for
The new number is, old suit was 1296 of 1950 and now probably a CS 6.
this is now or within ordinary jurisdiction.
Yes, Lordship.
So this GA Com should be changed.
Yes, Lordship. Lordship, I am a new.
This is for redemption.
Yes.
Lordship,
Redemption, and we had filed, kindly recall my lord, we had filed a supplementary affidavit. There are constructions being made by third parties. Now, if your Lordship will recall, the property was handed over to the court liquidator with a condition that they would manage and maintain the property on my expense, and they charge me for the expense. Now, they have lost the deed. Now, the property has gone out of hand. Now, kindly see what's happening. These constructions are being made.
Why there is a construction?
May I just indicate?
I am beseeching your lordship, kindly prohibit the construction, otherwise nothing will be left in this property.
My lord, so far as we are concerned, we appear for the.
Have you filed a supplementary affidavit?
Yes,
I have filed an opposition. I have prepared an opposition also.
Lordship, I have filed
I don't
an
know why he's
application.
opposing to the
I'm an intending purchaser, Lordship.
That is separate issue.
Lordship, that application, the advocate on records for the parties, Lordship, it's very difficult to serve upon them. May I serve it upon the councils appearing before your Lordship? The application needs to be filed immediately. I have a very good offer, what I understand from my client, Lordship, about 13 crores rupees, Lordship, out of which the amount that is due and payable to the.
The application I will accept.
Yes, Lordship.
I will hear, fix the date of hearing.
Yes, Lordship.
But that doesn't mean I will settle the matter.
Lordship.
That is between you, between the parties.
Subject to the merits of my application, Lordship, definitely.
Of course
Lordship.
that. I will hear it only.
Very well, I'm great. May it be recorded, Lordship, the GA number is 5, Lordship, and service is completed by.
GA is filed or not?
Lordship, upon service, it will be allowed to be filed, Lordship. What I understand, Lordship, with the
This
service.
RD, the learned counsel for the intending purchaser and oblique intervener. Please leave to file appropriate application for intervention
I'm grateful.
on service of the copies to the learned counsels. Full stop, leave is granted to serve copies of the application to the learned counsels. Full stop. Next para. GA Com 3 of 2023 shall be renumbered as the present suit is not a commercial suit. It should not bear with the number, the relics of commercial jurisdiction. Full stop. Department is directed to do the needful. Next. Where is your supplementary affidavit?
That we filed, your lordship. These are the recent pictures, your lordship. We've read it, Jaisha.
Supplementary affidavit is filed.
It was filed on the last date, your lordship. And it was served.
By the learned counsel for the defendant. Defendant praying for interim order or orders in view of the fact that there are unauthorized occupation and construction in the suit premises. Full stop. Where is your AO? Mr. Rai, the learned senior counsel for the official liquidator, files affidavit in opposition. Yes, what do you have to say?
One thing is this, two things on a point, purely on a point of law. But before I assist my lord on that score, may I just draw my lord's kind attention to the order of 3rd April 2025. May I, my lord, kindly come once to 3rd April 2025. My lord has got that order, my lord. 3rd April. No, the GA one.
Yes.
Yes. My lord, kindly see the we are not for my lord official liquidator. We are for the court liquidator. Unfortunately, my lord, as Mr. Bose while submitting also submitted that official liquidator has not done this official.
No, I said the court
Court,
liquidator.
so very good. Court liquidator. So court liquidator, it has come, my lord, everywhere as official liquidator. Kindly see the first appearance page, my lord, court liquidator. Then kindly come to my lord page 2.
Let me do one thing.
Yes.
This application, this order should be corrected.
Yes.
For correction, you come with an order, make corrections. It will be corrected accordingly.
One. So it will appear as to be mentioned, or
I will be fixing a date.
very good. So far that part is concerned. Now, my lord, so far as this part is concerned, kindly see, my lord, GA number. This is GA number 3 of 2023. Don't think, my lord, for a second that I am opposing. They say I have the responsibility of maintaining it. I say, as per the orders of this court, the responsibility of
So let a special officer be appointed.
Yes.
My lord,
Let us whether who has responsibility, not we will sort it out later.
No, one thing.
But some sort of interim protection at this moment. Otherwise, no one will get nothing out.
All right.
Official receiver, my lord, not the court liquidator. Official receiver is already in possession. That's the order of the court. So court is in possession. One can appoint.
Then official receiver should be asked to call for report.
Absolutely, they should have.
When official receiver was appointed?
My lord, official receiver was appointed. Kindly see the last orders. Official receiver came also to my lord's court and have filed a report.
All right.
Official receiver.
No, then official receiver will appoint. Will continue to do.
Yes. So official
because
receiver
if some other lawyer is appointed, then you have to bear extra cost.
Yes, that is.
Need not be.
And an official receiver has to say what he has done, because Mr. Bose's client should have served a copy on the official receiver. He should come and give a report to the court. That's necessary, because otherwise
the official receiver, the learned counsel for the official receiver has already been handed over. You got a copy of the application, supplementary affidavit?
No.
The copy of the supplementary affidavit be handed over to the learned official liquidator. Full stop. Official receiver. Full stop. The learned official receiver shall furnish a report on the returnable day on the present condition of the suit property.
In the meantime, your lordship, there should be an order of injunction from
No,
taking these constructions.
Let the report come first.
Yes, because whether you are doing by third parties or not, we don't know.
What is this kind of submissions Mr. Roy is making?
How long would you take? 15 days?
15 days, they will again raise the construction.
10 days.
And there will be substance.
No construction shall be made in the suit premises,
Without the leave of the court.
comma, no encroachment or occupation shall be made in the suit premises till the returnable date. Copy of this order may be communicated to the officer in charge of
police station. Devghar police station.
Devghar police station.
Sure, sir.
Or the
Superintendent of police, because this is a large property we find.
yes.
To the superintendent of police. Devghar.
Officer in charge, my lord, is something.
And also the office in charge
To
of the
stop any illegal activities. The landed register original site shall furnish a copy of this order, shall furnish a gist of this order, informing the relevant part. No, the landed register original site shall inform this, shall communicate this order to the learned, to the superintendent of police Devghar with a copy of describing the property in details to identify itself.
Not also CO Mohanpur along with the SP. There is a CO Mohanpur.
CO means?
Collector Mohanpur.
Copy of this order may be also be sent to the collector. Mohanpur is district or?
That is the area over there.
Let this be done. Let this be done.
The
learned official receiver shall visit the spot and furnish the report on 26 June, when the suit will appear in the list for hearing.
Along with my application, Lordship will kindly allow.
26 June.
This will take time. They have to go Devghar.
No, let them go to Devghar. But if the apprehension is correct, my lord, kindly give us an early date. This is our prayer. Because, my lord, if
application is not yet to be filed, then file it and mention.
Very good.
I will fix an earlier date.
No, 26 June, my lord, subject to again correction, my lord, to anything done within 48 to 72 hours visit. Thereafter, report another 72 hours. 1 week, 2 weeks. Kindly consider this, my lord.
20th May.
21st May.
21st May.
ছুটি পড়ে আছে তো।
21st May রাখতে তো অসুবিধা
না, না, আমার কিছু আসলে
At least some order may be necessary.
Yes, absolutely. That is why we have come up.
আমি তো support why are you opposing?
Today is 5th.
Yes, today is 21st.
Earlier date would be useless, basically,
Yes,
because you have to communicate this order.
Yes, 21st. No,
That you do. But at the same time, we must visit in the meantime.
Absolutely.
File a preliminary report at least. Did not file the final report.
21st May. And so far as the other matter is concerned, is it, my lord? Just
Which one, the other matter?
The corrections, my lord. The other.
Okay.
Or let that appear on that day.
The order dated 3rd May.
3rd April.
3rd April 2025.
Passed in GA number.
Passed in GA number
1 of 2023.
GA number 1 of 2023. Shall appear in the list on 7th May for correction. 7th May for correction.
Grateful, Your Worship.
I am not passing any status quo order as of now because I do not know against whom the order is to be passed.
There is, we have.
Let this be done.
Paragraph
More
6.
than enough. Because the court is in possession. Anybody doing it, summary eviction.
Yes.
Court
Yes.
must know what is going on.
Summary eviction. Correct. Summary eviction.
He is supporting you. Don't worry.
But he doesn't need my support. He has to.
And I hopefully that was not your contribution to that man.
That's the only thing.
I wish that day that was my contribution.
That was the only thing.
Unfortunately, it was not my contribution, but I hope so.
Today, matter is being litigated here. Who is doing there? Let a report come.
15. Item number 15.
May please, Your Lordship.
What is J9?
Reimbursement of
In this matter, I am appearing on behalf
Payments
of
were
all the
directed to be
defendants, Your
reimbursed.
Lordship.
Yes. On the last occasion, the report could not be found. I'm not too sure if it has been found now or not. But in any event, I'm presuming my learned friend is carrying a fresh report.
You need a copy.
Prepare another copy if it is not found.
Which report should I look into? This one.
Dated 20 March 2025, a supplementary report I have filed, whereby in paragraph 4 I have stated the remuneration which can be reimbursed.
Vouchers can be reimbursed. You have mentioned the vouchers, but what is the total amount of money?
I mentioned in paragraph 4, 3,51,005 can be.
Report of the learned.
In this matter, if I have the leave to submit, Your Lordship, I would like to place a report of the learned administrator dated 15th March 2023, Your Lordship.
Yes.
Thank you.
In this report, Your Lordship, kindly come to page number 6, the paragraph
must be on
number
the
9.
record.
Yes, your lordship. It's there in the report. Page 6, para 9, your lordship.
এটাকে ঠিক করো তো। Yes.
In this paragraph, your lordship.
Which paragraph?
Page 6, para 9, your lordship. Furthermore, by a letter dated 19th December 2022, Mr. Anirban Pal, learned advocate for the Caveatrix, has requested to disburse the pending salary of Mr. Probir Mojumdar, the manager of the Sundarban property, for the period from July 2016 to November 2022 at the tune of rupees 5,000 per month, aggregating to rupees 3,80,000 only. And as on date, the outstanding salary of Mr. Probir Mojumdar for the period July 2016 to March 2023 amounts to rupees 4,05,000 at the tune of rupees 5,000 per month, which is for 81 months, your lordship. This is still pending. These are all statutory dues. And your lordship, kindly come to the paragraph number 11, your lordship.
In addition.
Yes, your lordship. In addition.
Then salary of Bimal Krishna Jana.
Yes. Thus, the salary of Mr. Bimal Krishna Jana is looking after the Kolkata properties, and Mr. Probir Mojumdar, Mr. Anup Mondol, and Mrs. Purnima Mondol are looking after the Sundarban property, whose monthly salary
Is it cleared?
Yes. No.
May I submit, lordship? The report which I have submitted, lordship, there was a direction by the court that certain vouchers they have submitted before me to just scrutinize those vouchers and give a report before the court which vouchers can be reimbursed. That report is before this court today, lordship.
So one is reimbursement of these vouchers. First thing. Second thing, these dues.
Yes, your lordship.
The other side has put certain objections. That's why this has not been cleared, lordship.
No objection in respect of the staffs of Sundarban property has been raised, neither by the plaintiff nor by us, your lordship.
No, lordship, regarding the property.
All right, please.
No.
My lord, so far as the expenses which have been incurred by me, my lord.
Two reports are there.
Yes.
One is this one, 5th April 2023.
My lord.
Have you got the report?
Yes, 15th March. No.
Yes. This is dated 15th March 2000.
No, 5th April.
Yes.
5th April.
My lord. 5th April, yes.
Now certain expenses are to be borne, are to be reimbursed, especially salaries of certain persons.
Yes.
This amount comes to, again, it is not there.
It comes to your lordship. It's 4,05,000, your lordship. It's in page number 7. It's there in the application. It is according to the prayer B of this GA9, your lordship.
This is salary of Probir Mojumdar.
Yes, your lordship.
From July 16 to March 23 amounts to 4,05,000.
Yes, your lordship.
Now this apart, salaries of Bimal Krishna Jana.
Yes, your lordship. And along
so
with
this
that,
is 4,05,000 plus something more.
Yes, your lordship. Yes, your lordship. The salary.
So aggregating 18,400.
No, your lordship. This is aggregating to the monthly salary of all these persons. But your lordship, we have objected the entity of this Mr. Bimal Krishna Jana. But we have not objected in respect of the entity of any of the staffs of Sundarban property, neither the plaintiff nor us. We have said that we do not have any objection in respect of disbursement of salary of the staffs working over there, your lordship.
All right. First thing, one report is for reimbursement of voucher.
Lordship.
To whom it is to be paid?
To me.
You are?
I am either the plaintiff who was administering the estate.
Right. To the executor.
In this regard, your lordship, they have already taken out that amount from the account of the executrix, your lordship. This is very much apparent from their supplementary affidavit, your lordship.
No, if this amount has been taken by them,
Yes.
is it going to be a double payment?
Yes, your lordship. Yes, your lordship. It is very much apparent from their supplementary affidavit.
You do one thing.
Yes, your
I am
lordship.
placing these two reports.
Yes, your
Come
lordship.
with your exceptions or
Yes, your
comments.
lordship. Yes, your
That will be clear.
Yes, your lordship.
My lord, may I just take 1 minute, my lord, to make my submissions, my lord? So far as the expenses which I have claimed, my lord, I have filed a formal application for the same. Time to time orders have been passed, my lord, directing, my lord, the learned administrator pendant light to consider my vouchers, consider their objections, and thereafter finally pass a report or finally pass an adjudication of sorts determining how much is due and payable to me. My claim was, my lord, for roughly about 9 lakh. After considering all his objections, after considering all the documents records, the learned administrator pendant light has said that out of this 9 odd lakh which I have claimed, I am entitled at this point of time to about 3.5 lakh. So this is what I am praying for today. So far as my balance claims are concerned, my lord, I will have to further press my GN9. That is number one. So far as the claims which Mr. Pal is claiming, my lord, he has not filed any application in this regard. He has to first file a formal application seeking reimbursement of claims.
You are seeking any reimbursement?
It's there in their application GA number 9, prayer
Where
B,
is
your
GA number
lordship.
9?
Please come to the prayer B, your lordship. Prayer B, your lordship. A specific direction be passed by this honorable court directing the learned administrator to pay salaries of the staff of the estate of the deceased testatrix as per details of Annexure G, your lordship. It's there.
So it is there.
It's there in the GA,
In
your lordship.
Annexure G, my lord, subject to correction.
Whatever that
Mr.
might be, if some money is due and payable that appears from the report, that definitely can be considered.
Yes, if the learned administrator feels that the money should be paid to Mr.
Yes.
Probir Majumdar, then yes, of course.
Still
But
one
there
more
is
thing.
no- there
Some
is-
exceptions are to be filed. If you want to file some exceptions.
Yes. But so far as my claims are concerned, which after considering his objections, the learned administrator.
report is there.
That there's a final report. Kindly, my lord, at least direct, my lord, the administrator to discharge this payment to me.
Come together. No exception is there against any of the report.
No.
Giving a short date. File exceptions. I will hear that. Because he has something to say. You have something to say. Reports of the learned administrator pendant litigation dated 5th April 2023 speaks in favor of payment of certain amount of money towards salary of the staff. You never calculate the whole amount. That is the problem with you. You have written this as in the so far as this application, this report is concerned. Probir Majumdar will get aggregate 9,08,000.
3 lakh.
3,80,000.
And what about 9,80,000?
Page 7, second line.
That is for Probir Majumdar. For others?
The others here.
For others, Bimal Jana, you have also stated Bimal Jana and another person,
Your lordship.
Purnima Mondol. They are to get money.
Yes, your lordship.
We have not calculated that.
Lordship, kindly see page 8, paragraph 11, Lordship.
Yes, I am seeing this.
Yes, I have given the exact chart.
Total monthly salary is 18,400. What is the due? Is there any past due?
Yes, Lordship.
What is that amount?
Should I shall state again, Lordship, I have given the chart which are dues, Lordship. Total outstanding. In page 5, Lordship, I have given the chart.
Yes, you have given a chart.
Total outstanding per person, I have given the details, Lordship. The period they have claimed, May.
So
18.
total amount is 9,08,000.
Yes, your lordship.
9,08,000. Now out of this 9,08,000, some reimbursement are to be made by him. To him. Is it included? Not.
No, your lordship.
The vouchers are separate vouchers. And this is only in respect of the salaries, Lordship.
All right.
And in this regard,
The
your
report of the
lordship,
fresh code likhun to, report of the learned register, learned advocate, administrator pendant dated 5th April 2023. speaks in favor of disbursement of outstanding salaries. Full stop. The report of the other report dated 20th March 2025 to be read with the report dated 10 February 2025 as well as the report dated 30th January 2025 speaks in favor of reimbursement to the plaintiff in respect of vouchers submitted. Full stop. Exceptions, if any, shall be filed on or before the returnable date. All these reports shall be considered on the next date, on the returnable date. The matter will appear in the list on 17 June.
I'm grateful to you, Lordship.
My lord, one small issue, my lord. My learned friend keeps saying that he has filed an application to bring on record certain
Yes, Your
documents,
Lordship.
but I see nothing. There's no movement.
No, there's no application is lying with the master, Your Lordship, until and unless we get it back from the master.
All right.
My lord, he has to take steps, my lord. He's just leaving it
We are
pending.
taking steps. We are taking
If he is interested in this application, moving this application,
Yes, Your Lordship.
he is interested in moving this application, he will take steps. Otherwise,
Yes, Your Lordship.
My lord, kindly see my predicament. His witness is being examined. After he
Yes,
finishes examination, I have to cross-examine.
Yes, Your
So
Lordship.
my trial of the suit, my lord, is being delayed because of
there
his
is no
inaction.
delay. Unless the application comes,
Yes, Your Lordship.
I cannot pass any order. I cannot hear to file additional documents. If suddenly with additional documents are filed, that will not be allowed.
Lordship.
It is their headache.
My lord, at least then fix a date for his witness to come. If his application is not
Witness action, no date.
no date has been fixed.
The suit will appear for witness action on 13 June.
I'm grateful.
13 June.
Lordship, I want to make some submission, though it's very embarrassing for me. Lordship, kindly direct the defendants not to put the remuneration of mine as and when they feel like they deposit amount in my account. It's very difficult for me to keep track on the what
In this
regarding
regard,
which month they say they are sending. Different persons are sending the amount. It's very difficult for me to keep track. I've requested many a time.
in this regard, Your Lordship,
Regarding the dues.
in this
Are you so important that I have to ignore her?
I beg your pardon. I beg your pardon. I beg your pardon.
It's very difficult for me to keep track on the which month they are saying which remuneration.
Are you getting, do you getting your remuneration regularly?
No, Lordship. When they feel like they deposit certain amount.
Come on the next day. I will pass order.
I'm grateful to you, Lordship.
Grateful, my lord.
Item 16.
I was praying for a Passover, Your Lordship.
No Passover. Not today.
Today. Grateful, Your Lordship.
17.
17, my lord, this has come up on my instance, my lord. My lord, this is the last order, my lord. This is for the extension. This has come up for the extension,
Extension of what?
my lord, to reaffirm the affidavit of assets, my lord. My lord, this is the last order wherein, my lord, the order for amendment of the affidavit of assets was passed, my lord. My lord, the petitioner's husband, my lord, is suffering from liver cirrhosis, my lord. That's why she couldn't come and reaffirm the affidavit of assets, my lord. So I was praying for extension of that extension to just reaffirm the affidavit of assets, my lord.
Time is extended to reaffirm the affidavit of asset till 24 June.
My lord, in this matter, I will to appear for the one of the legal heirs, my lord. My lord, I have lacking instruction from my client, my lord. I could not contact my client. So, my lord,
Come on the next date.
my lord, kindly record the submission because otherwise I don't have the.
My lord, on the last 3-4 occasions, they have not been appearing, my lord.
Then your name will
For
be there
occasions,
this
my lord.
much.
Grateful.
Your reply.
I was in reply, yes. Millard, just to recapitulate, Millard, what I had submitted. My learned friend, in his argument, my question of jurisdiction said that so far as the issue regarding this court taking up and deciding issues arising out of land acquisition matters, he says that so far as the law is concerned, law gives him a right, and under the law, possession is the date from which he is entitled to. That has to be ascertained. And the date when the actual acquisition took place. He had said so in so many words, he has filed a dated note, which I had placed on the last occasion, where his primary question was that this is a case where the first issue that is required to be answered, if your lordship takes his notes once, my lord, lordship is not there. File two notes.
First or second?
My lord, lordship will take the second note because the first note or my lord, I don't know which one is the first, but one note starts with.
Take it. I have my notes.
First note, with judgment.
There's my handwriting. First note, second note.
Second argument. The instant suit is the first argument. Kindly take the second argument. Lord, the way he proceeds is, my lord, he has described the various dates on which, my lord, various proceedings were initiated in respect of the property. Then he refers to the acquisition proceedings, the dates of the acquisition proceedings. And my lord, at paragraph 11, at page 5, he says that in view of the above, the following points are required to be decided. Whether the vesting under Act 2 of 1948 continued from 1960, August 1986 in this case. This is his first case. Based on this finding, his second issue is whether the defendants are in unauthorized occupation from 1/6/86 to 10th September 2007. So the finding of one will have a bearing on the finding of two. The basis of this framing this issue, Miller, he has set out in paragraphs 4b onwards. He has taken the legal code to say that, well, if your lordship sees from paragraph B, acquisition proceedings initiated under Act 2 of 1948 was not continued and no award could be passed in the said proceedings for acquisition. Page 3, paragraph G.
Yes.
This is what he says. That, well, if I may start from F so that it can have continuity. In March 1991, the defendants delivered possession of the eastern part of the premises measuring 22 kata such and such to the plaintiff. But the defendants continued to possess and occupy western part of the land measuring 15 kata, 5 chatak, 14 square feet.
Which paragraph you are reading out?
Well, at paragraph F at page 3.
Yes. 23rd May.
Yes. On 23rd May, he says he have given the eastern portion, but the defendants continued to possess and occupy western part of the land measuring 15 kata, 5 chatak, 14 square feet, two-story building and outhouse standing there. This possession is the subject matter of dispute in this suit. The acquisition proceedings initiated under Act 2 of 1948 was not continued and no award could be passed in the said proceedings for acquisition. The plaintiffs got rental compensation up to May 1986. That is why, my lord, he is claiming from 1st June 1986. In respect of the entire premises at 777 per month, as was determined under the 47 Act, and thereafter further rental was paid to the plaintiff. The defendants continued with possession of the entire property up to 1st May 1991, and on and from 2nd May 1991 continued possession in respect of 15 kata 5 chataks of land with two-storied building and outhouse without paying in rental for use and occupation of the premises. Ultimately, government published a fresh notification under Section 4 of the ALA Act on 13 December 94 for acquisition of the western portion of the premises. The said notification was challenged. Then single bench quashing the notification, defendants went up in appeal. Judgment of division bench was set aside against the judgment, and the division bench set aside the order of the learned single judge against the said order of by the appeal court. The plaintiffs moved to Supreme Court. The SLP was admitted for hearing. In the SLP, interim applications were filed praying for payment of damages, rental, such and such. From time to time, the Supreme Court passed directions upon the state to pay compensation. In the process, by order of the Honorable Supreme Court, the defendant paid to the plaintiff the sum of 1 crore 28 lakhs and ultimately disposed of them, giving liberty to the plaintiff to have recourse to other remedies. So therefore, he says the plaintiff remained in wrongful possession during this period, and therefore his first issue is whether vesting under Act 2 continued from 1986 in this case. To that, my reply was that so far as this issue is concerned, which is the crux of the matter, my lord, this issue has been finally decided between the parties in respect of the same property in the previous set of litigations, where, my lord, the court has said that from the tenure of possession and the manner of possession, it appears that there has been no break of possession and the land and the state continued with the possession till such time the proceedings initiated. And that finding of the division bench, my lord, was approved by the Supreme Court in that very large judgment, where it says that the division bench finding is correct. Now, my lord, if your lordship takes our notes, final note,
Yes.
my lord, what we have done is from paragraph 9, I have set out the relevant portions of the Supreme Court judgment. In this context, certain portions of the order of 13 December 2006 passed by the Honorable Supreme Court are relevant and set out. Now, my lord, for your lordship's convenience, my lord, this order of 13th of December 2006, your lordship will find
13th November.
Yes, my lord, 13 November 2006, my lord, your lordship will find
Judge's brief.
Yes. Lordship will find at page 187. Directly. A project document. Yeah.
Yes, it is there.
Yes, sir. Kindly take the trouble, my lord, of coming to page 202. The lordship will find the second line at page 202, which is written at page 15. According to the appellant, the notification has, my lord, got it. First. My lord,
Yes.
It starts with this is what was contended. According to the appellant, the notification under Section 4 of the Acquisition Act would not have been valid. Supreme Court. Page 202, internal page 50. According to the appellant, the notification under Section 4 of the Land Act would not have been validly issued in respect of the land possession whereof have been retained illegally by the state. So that was the issue. It is further incorporated the government of India earlier been continuing possession of the land only in terms of requisition order of May 1986. The said order of requisition having been quashed by the court's order of August 1993, the government's possession of the land sought to be acquired became illegal and unauthorized. So the asserted that having abandoned the earlier proceedings initiated under Act 2 of 1948, as is evident from the fact of publication of the impugned notice under Section 4 read with Section 4 of the Act 1 of 1894, the government had lost the right to retain possession of the land. Possession would have been taken only in terms of the provisions of Section 60 of Act of 1980. Then it was further asserted the government publishing notification while illegally retaining possession of the land sufficient to hold back the problem. So, the crux question is whether my A was illegal. Now, kindly come to page 22. Page 22. The High Court was correct and justified in holding that while examining the validity of notification under Section 4 of the Land Acquisition Act, the question of possession of land was absolutely irrelevant. The division bench held that the order of 18th August 1993 was per incurious. The High Court observed that the learned singular was wrong in holding that the publication of notification under Section 4 of the Act done in violation of the order of 18th August 1993. According to the division bench, the learned single judge proceeded on a completely wrong premise and that the land in question had been kept in possession by the government even after formally de-requisitioning the same, for as a matter of fact, the piece sought to be acquired had never been de-requisitioned after 30th January 1959. It is rather stood absolutely vested in the government. This is the finding arrived at between the parties. The division bench clearly came to the conclusion that the state government's possession of the land never became illegal or unauthorized by operation of law. The division bench specifically observed that the declaration published on 7th August in the official gazette has been produced before them. The division bench observed that they were satisfied that the words partly at public expense and partly at expenses within the aforesaid award published in the newspaper did not correctly reproduce the declaration issued in Section 6. The official gazette had correctly incorporated the land was acquired at public expense only. Therefore, the division bench did not find any infirmity in the Section 4 notification in the declaration of 23rd June 95 made under Section 6. Then, the division bench was also justified in coming to the conclusion that the appellant cannot be permitted to take advantage of some typographical error in the newspaper when in the official gazette as Section 4 of the Act, no such mistake appeared. It may be pertinent to mention that the division bench was quite careful about the rights of the appellant, that is, my learned friend's client, and various proceedings and orders passed in the proceedings. While taking into consideration all the relevant facts and circumstances, the division bench clearly observed as under, and we deem it appropriate to quote the relevant observation of the division bench. Then the observation is quoted. We have already seen that there was an unbroken, continuous, valid requisition which had ultimately merged in the acquisition notice of 14th August 1986. Therefore, to whatever rent, compensation or damages the respondents are entitled to, they are always and still are at liberty to claim, realize the same from the government in accordance with law. Has my lord got it, my lord? They are always, and regarding the propriety and necessity of the publication of notification dated 13 December 94 under section 4(1) of the Act of case of the division bench decision that is such and such, we do not propose to express any opinion lest we should allow the appellants to challenge their own action to inevitable detriment of valuable accrued rights, if any, of the respondents. We only say that in our view of our decision, we allow the appeal and uphold the section 4 notification and consequent section 6 declaration. We do not think it proper and necessary to pass any further order.
You are reading out page?
Page 25, where we note the division
Yes.
bench order has been quoted.
Division bench allowed the appeal and set aside the impugned judgment.
Yes. So the challenge to the accusation was gone. The Supreme Court had affirmed the view of the division bench that there was continuous possession of the state from 1959 and there has been no break. Then the division bench allowed the appeal set aside the impugned judgment of the learned single judge dated 2nd October 1996. I am reading continuation of that, page 212, last paragraph. The division 212, last paragraph.
Yes.
The
Allowed the appeal and set aside the impugned judgment.
Yes. The division bench has observed that the appeal would be entitled to recover rent which he is still entitled to in law in appropriate proceedings. The appellant has failed to point out any infirmity as per the notification 4 and 6 is concerned. Usually assailed on the ground of public, we deem it fit and appropriate to enumerate the public purpose, and thereafter it goes on. Then, kindly will come to page 46, having page 46, that page, yes, page 233, I'm sorry. I'm obliged to my lord. No. Page, internal page 46, turning page.
We have heard the learned counsel.
For the appellant, then we also carefully examine the pleadings, documents, judgment such and such. We see no reason to interpret the well-reasoned judgment passed by the division bench of the Calcutta High Court, but we have given liberty to the appellant to cover and count appropriate proceedings in accordance with law. So, my lord, coming back, my lord, to the first query in the note.
Second notes of argument.
This stands answered. So, my lord, all the arguments that my learned friend tries to make as regards the applicability of law, when did he take possession, when was in possession, my lord, all gets, my lord, consumed or subsumed by the previous set of litigations between the parties, where, my lord, ultimately it rested with the Supreme Court saying that the division bench is correct in saying that the state's possession was not illegal and it continued from 1959.
At liberty to recover rent compensation.
Appropriate proceedings. To that, my answer was that when the suit was filed, there was no award. So that's the reason, my lord, my learned friend proceeded on the basis that we are in illegal possession and we continue to remain in illegal possession. At that time, no award was passed under the land acquisition proceedings, and therefore he is claimed the entirety of that period as in wrongful occupation. Now, my lord, he cannot today claim that in view of the judgment of the Supreme Court which has come subsequently, he could not have today claimed that I am in illegal possession, number one. Number two is, he is entitled to claim compensation. Now, compensation he has to claim, taking into consideration the award, which is at page 268. Up from 267 million.
Yes.
Document 5, this is the award which has been marked by the land acquisition collector. And my lord, whatever he has been awarded.
Was it marked?
Yes. Without objection, it has been marked, but I did not object.
No, it's an award.
Because in award, it's a government document. No problem.
And my learned friend has taken the compensation which has been awarded to him.
Yes.
Your lordship takes the trouble of coming to page, internal page 2 at page 268 of the award.
3195 to 1447.
Now take the plate. Keeping that side by side. Oh, yeah, awarded a period. Will you kindly come to page 14, paragraph 22, plaint and injunction.
Paragraph?
Paragraph 22, page 14.
Yes.
For the period 1st June 86, it is from 95 till 2007, 86 till 2007. The plaintiffs are entitled to damages for rent, use, occupation of the western portion such and such storage building, which is assessed at 9 crore 88 lakhs 24,000 for the period 86 to 2004, and for the period August 2004 to August 2007 at 70 lakhs and all. Of this, from 95 till 2007 is covered by this
award.
So now we are left with the only claim from 86 to, if at all, that is sustainable. My contention is that my learned friend has taken the award, he's received it, he's withdrawn the compensation without reserving any right, and that too, Millard, as long back as in on 15th of November 2007. Millard, your lordship will find at page 270, internal page 4 of the award.
Yes, there is a handwritten notes.
Yes, handwritten note, issued check, issued check, issued check, issued check.
There it is mentioned.
Yes. So now the question is,
Estoppel.
A, B, if there is no challenge to the award, so if my learned friend wants to contend that he is entitled to something more from 1986,
Possibly 18 to 2008. 8 or 18.
1918, it's 19. 19 to 2008. Amount paid, date of payment, and remarks.
In 2008, February 2008.
So, and the suit is of 2007. So, pending a suit, he has accepted the award, which covers the major portion of his claim. He is left with a period anterior to that, not posterior. So, the day he took the amount, he collected the amount from the award collector, Millard. On that day, which is 2008, the Supreme Court judgment has already come, 2006. And that Supreme Court judgment affirming the division bench judgment had said that there was no illegal possession. So, Millard, he was to be best advised, but I would have understood that his right to sue for the balance, if at all, had arisen on that day when he knew that the award does not contain the claim for the period 1986 till 95. But he has neither amended the plaint, nor has he challenged the award, nor has he taken any steps before the land acquisition collector for this period. Today the question is, A, estoppel. B is, even assuming for the time being, I say that I apprehend my learned friend will say that once the Supreme Court has said that I am entitled to compensation, there cannot be an estoppel in law. The question is, end of the day, what are you asking? Your plaint proceeds on the basis that I was in wrongful possession. You have challenged it, and the finding that has come is from 1959, I was in valid legal possession. So it cannot be mean profits. It cannot be damages. It can be at the highest. At the highest, it can be compensation for using your land.
Occupational charges are to revert that point.
Occupation charges, which under the Land Acquisition Act.
Any money payable on account of occupation.
Yes. So for that, if your land is hit by not by a contract but by acquisition proceedings, your proper remedy is to approach the appropriate authorities. Supreme Court has not said, my lord, that the suit that is pending is the only proceedings where you can. Because presumably, my lord, that suit was filed in 2007. He thought that 2007 suit would cover the period during which the Supreme Court's finding that I am in possession from 1959 and correctly in possession in 1959 can be set at naught. But my submission is that finding operates as res judicata so far as the parties are concerned. He could not have reopened that issue anymore. If he could not have reopened that issue anymore, the basic structure or the frame of the suit that I am in illegal possession will not goes. Your lordship sees the plaint, your lordship will find that his basic structure of the plaint is I am in illegal possession, which has been negated by up till the Supreme Court. So if I am not in wrongful possession, he is entitled to compensation. That is what the Supreme Court says. But at the same rate says before the appropriate proceedings. Now I have, my lord, cited two authorities to show, my lord, that if any claim arises out of acquisition proceedings, then, my lord, it is the collector or the appropriate authority, and the civil court's jurisdiction is ousted by virtue of section 9 of the Civil Procedure Code. Because there is a tribunal, there is a forum, there is an act. Court does not have jurisdiction. That is my first point, and that I had already argued. The second point, my lord. So, my lord, coming back before I go to the second point. So, if the date of vesting is answered by the judgments of the Supreme Court, then, my lord, the next unauthorized occupation from 86 to 2007, my lord, is no more journey. It cannot be an issue any further because this issue is decided. If your lordship wants, my lord, I can place once again that portion of the judgment of the Supreme Court where, my lord, it is very unequivocally and correctly, I do not say correctly because the judgment of the Supreme Court has appropriately answered by saying that it was never in wrongful possession. At page 23, my lord, lordship did not be bothered, I'll just repeat. The division bench clearly...
So your point is, there you are in rightful occupation, that is adjudicated upon or observed by the Supreme Court of India as well as the division bench. Rent compensation is given by you from 92 to 2007. So only 7 or 8 years is left.
For the anterior period, for which there has been no proceedings before the appropriate authorities.
And this is not the appropriate forum.
Absolutely not the appropriate forum. And for that,
so that part of the claim is not tenable.
Entire portion of that claim is not tenable.
But later part is not tenable because they have already taken compensation. Former part, so far as former part is concerned, this is not the forum.
And, my lord, it is no more today open to either of the parties, my lord, to reopen the issue as to when possession took place, when possession certificate was issued, when notification was given, when it was actually taken possession of. my learned friend's first note was an attempt to go into these issues, which, my lord, to me, I believe my complete answer is this two-line finding with the detailed finding of the division bench, why I was never in wrongful possession, and all the proceedings starting from requisition and ending with the Act of 1984 was justified. So it is no more res integra, it is no more open to him to re-argue this point. Nor, my lord, with utmost respect, my lord, can this court...
This you have put your note in, have you put?
Yes, my lord, I have quoted that paragraph.
No, not paragraph, the sum and substance of your argument.
Yes, my lord. I have not only quoted the paragraphs, I have also gone forward from paragraph 14 onwards. If your lordship sees me, I know.
Yes.
Paragraph 14, no rental damages
Yes.
can be claimed by the plaintiff for any period subsequent to by filing a civil suit in this honor of the said property.
All right, these are your answers.
Yes. Now, my lord, the second point, which lord, I would, my lord, and I have also annexed the authorities on the basis of which. আমাদের নোটটা
But no judgment, no decision is there without notes?
Yes, my lord. I have cited, not only have I referred to, my lord, in the notes, I have also cited, দেখুন তো আলাদা করে চলে গেছে। এই দেখো কবে কোথায় ফাইল করেছো। 1995 4 SCC 229 দেখুন তো আছে কিনা। List of dates আমি নিজে দিয়েছি জাজমেন্ট, আমি টাইপ করেছি।
Yes, these judgments are referred to 95-4 Supreme Court cases 229
2013 volume 3 Supreme Court cases page 66
and 1996-7 to 18.
Yes.
But where are the decisions? Citations must be here. দেখো এটাকে স্টিচ করে দাও এর সঙ্গে। All three are there?
Yes. Now, my lord, my second portion of the argument. This is so far as, my lord, the plaintiff's claim is concerned. Now, my lord, we have a counter claim. Kindly take the written statement also. Lordship, written statement at the end. Will it kindly, will it come to 21 onwards. The facts and circumstances of the case as set out in paragraph 4 herein above, and the defendant craved leave to treat
Written statement, which paragraph you are referring to?
paragraph 21.
Yes.
Millard, in paragraph 21, Millard, I have set out the entire referred to paragraph 4. Paragraph 4, Millard, your lordship will find consists of various sub-paragraphs where the entire history has been of the previous litigation have been set out in gist. Honorable, then Millard, sorry, here now the defendant craved leave to treat the same as part of this counterclaim. The defendant state that in terms of the order of the Honorable Division Bench FMAT 224 of 1987, that is the division bench which was affirmed by the Supreme Court, the property in question, that is the building such and such, vested in the government of West Bengal under 4(1)A of the notification of date dated on 1st August 1986. In spite of such vesting and in view of the litigations pending before the parties herein, the defendants paid to the plaintiff diverse sums aggregating to 1,28,20,000 as per particulars below. These are the particulars given. The plaintiffs have admitted receipt of such payment in paragraph 22 of the plaint. All such payments were made in pursuance of the orders passed by the Honorable Supreme Court and directed to be paid on ad hoc basis subject to final determination in the appeal. I shall presently place those interim orders. Apart from the above, the defendant paid a further sum of rupees 95017 on ad hoc basis, calculated at the rate of 777, being the amount of rent compensation determined from 5th October 1959. That is where, my lord, the Supreme Court said is I am in possession, rightful possession from 1959. From 1959 for the period June 86 till August 1996. All these are admitted facts.
Paragraph?
My lord, paragraph 26. Which have been received by the plaintiff on 21st August 1996. Thus, the defendant has paid to the plaintiff and the plaintiff has received a sum of rupees 1,29,15,017, being the aggregate of ad hoc payments mentioned in paragraphs 23 and 26 herein above. Well, pausing here for a moment, over and above this, they have also received the awarded sum.
This rental was paid for this period.
From 19th, for the period starting from February 1959. Well, that I have stated till June 1986. For the period June 86 till 1996. Ad hoc payments were made, my lord, ad hoc, your lordship knows. It was, Supreme Court said you go on paying subject to the result of the appeal. The result of the appeal was the division bench order was allowed, the appeal was set aside, the appeal was dismissed, division bench order upheld, and for any claim the parties were left to go before the appropriate proceedings. So he receives 1,28,00,000 pursuant to orders of court. 129 is the total at the rate of 77 plus the awarded sum. So as of today, he's already received more than 2 crores and all.
So you have claimed back which one? Which part?
Millard, then Millard,
previously paid amount.
Yes. The compensation for acquisition of property has been duly determined and the plaintiff has received payment of the same without any adjustment. In the circumstances, the plaintiff is liable to refund to the defendants the said sum of 1,20,00,000 being the aggregate sum of amounts paid under 23 and 26 herein.
Which paragraph you are reading out?
Millard, paragraph 29 and 30. My contention is that
written statement দাও, ওই জন্য গন্ডগোলটা হচ্ছে আমার।
আপনি বললেন আমি দিয়েছি, আমি পড়ে যাচ্ছি তখন থেকে।
প্লেন্টিফেরটা দিচ্ছ কেন?
I'm sorry, Millard, I did not understand. Millard, I'll repeat myself, Millard. Kindly come to page 19 of the written statement. Huh? The facts and circumstances of the case has been set out in paragraph 4 herein above, and the defendant came to do this as part of the counterclaim. Then, the defendant state that in terms of the order of the division bench of such and such, the property in question, that is 15 feet vacant land, so and so has been acquired by requisition of so and so. In spite of such vesting, and in view of the litigations pending before the
So you paid 128.20.
This is an interim measure.
This you are asking for.
Millard, I am asking for this coupled with, Millard, the payments made in paragraph 26.
95.17 on ad hoc basis.
Yes. The total
From
of
86, June 86 till August 96.
The reason why I say so, Millard, all these ad interim payments, Millard, were made subject to the outcome of the award. The award has been passed. Award has not been challenged. Amount money received.
So nothing is left according to you.
Nothing is to be. Till he gets an adjudication that he is entitled from 86 to whatever he has claimed in the plaint.
So according to you, once he has accepted the award amount, these claims are redundant and these claims are to be refunded.
So
rather, these are overpayment.
Yes. So the money which you are holding, which is the government money, Millard, which you are holding, you are retaining it. It was paid to you subject to the outcome of adjudication. Adjudication has come for a lesser amount, which you have accepted and withdrawn. Now comes the question that these ad interim payments which were made pursuant to litigations, what happens to those payments? The award did not say, or the collector cannot say that monies which have been paid by way
Supreme
of
Court has also not decided this.
Supreme Court has said kept it open. Supreme Court has said that your right to claim rent compensation go before the appropriate authorities. My learned friend says that this suit court is the appropriate authority. I am saying that no, suit court cannot be the appropriate authority because the period of your claim, my lord, is covered either by the Requisition Act or the Acquisition Act.
But when Supreme Court has passed order asking you to pay interim amount,
Yes.
it is not made clear that this amount is subject to refund or subject to outcome of the award proceeding.
The question of interim payment, the basic concept of interim payment is the subject of outcome of all the results. In fact, my lord, my lord, at page 233
Of Judge's brief. Which court?
whatever it is, my lord.
Page?
Page 233, page 46.
Yes.
My lord, this is what was the ultimate direction. We have considered answer, we clarify, examine the pleadings, such and such in our dispute judgment. We see no reason to interfere with the ordinary division of Calcutta High Court. They have given liberty to appellant to recover rent compensation damages in appropriate proceedings in accordance with law. So, if this is the parting words of the Supreme Court, my lord, there is no observation by the Supreme Court that the interim payments made, my lord, would, my lord, be retained by him. Because for the Supreme Court to say that, that would, my lord, mean that he is entitled to this amount. Now, my lord, kindly see the interim orders of the Supreme Court. My learned friend and annex come to his plaint. I'll place those.
Paragraph, page?
My lord, I'll tell you. Lordship. Kindly takes the plaint once, my lord.
Plaint?
Plaint. This is 13th of August 2004. Having heard learned counsel on either side taking note of the facts and circumstances of the case, we think it just and appropriate to direct the respondent to pay a sum of rupees 5 lakhs to the appellant within a period of 10 days from D-Day purely as an interim measure. So this is ad hoc. The High Court of Calcutta is directed to appoint a valuer from the original site to fix the rental value, damages, occupation charges of the property in question from 86 till 2004. The High Court to submit the valuation report within a period of 10 weeks from today. The direction is accordingly disposed of. My learned friend obtains this order. Swapun Chatterjee, High Court, such and such valuer has come to the conclusion that the valuation of the property was assessed at such and such in rental value per annum on such and such, and the damages assessed for the period 86 till end of July 2004 are to the tune of 552,700. The objections to the
5 or 3?
3 is 52,700. The objections to the report have been filed by the respondent land acquisition collector and along with the...
Have you any copy? Have you any copy?
Of
this order?
Yes,
it is a little bit obscure, whether 5 or 32. Is it 3 or 5 or 32 or 52?
I think, my lord, it should be... Then I think I have a better copy. সুপ্রিম কোর্টের ওয়েবসাইট থেকে পড়ছি 30 পেজে হ্যাঁ 30 পেজ কি না এটা 552 it's 5
That appears to be 3.
oh next 5 is similar to this. The objections to the report have been filed by the respondent land acquisition collector along with the valuation report has been filed of the collector himself, which assesses the damage for the opposite period at 5097, out of which after payment of 20, the balance amount payable is 30,11,710. By directing payment of rupees 30 lakhs within a period of 4 weeks, the respondent may, if so advised, get the valuation report of Shopun Chatterjee examined by another government valuer and submit his report before this court. The valuer so appointed by the respondent, we direct would objectively consider the valuation of the property, its present rental value as per value per annum, as also the damages for the period 86 to July 84. The report of Shopun Chatterjee shall be sent to the valuer so appointed. The valuation report shall be filed in this court within 4 weeks. We, however, clarify that the aforesaid order should not be construed to mean that we have either accepted or rejected.
Irrespective of this order. Irrespective of valuation report without adjudicating upon the same.
Then, my lord, there is another order at page 31.
Yes, it should be 552. That appears from page 32.
Yes. Present in IA, owners of the building at Pretoria Street, Government of West Bengal issued 4-1 notice. It had issued such and such. Lordship can skip that.
25,000 per month. 25 lakh.
The bungalow in which the property was situated is being occupied by Police Department, West Bengal. The dispute arose as to the quantum of amount to be paid towards damages for use and occupation, and a special valuer was appointed by this court to fix the rental that had to be.
Now, what was the fate of this 25 lakhs?
I think this was also paid. Paid. Page 20 of my written statement, Willard. I have set out whatever I have paid with particulars. Page 20 of my written statement.
Amount paid was adjustable.
Yes. Has to be, Willard, because
that is there in the order.
Yes. That is what I was trying to come to. Your Lordship.
Amount already paid by the respondent should be adjusted towards the damages for use and occupation. Page 33.
Yes, Willard.
Yes, next.
And thereafter, Millard, the final. So this is an order of Millard.
Then this order was passed.
This is an order of Millard. This is an order of July and
11/7/2006.
And
then final order on
13 November 2006.
Okay.
So, Millard, if this was the directions that were made, and Millard, the ultimate authorities have crystallized an amount, by learned hands, right to withhold this amount, Millard, as per the direction, Millard, doesn't remain. He may argue that from 86 till the period the award did not include, Millard, I'm entitled to this amount. But Millard, for that, he has 3 hurdles to cross. For that, he has to ascertain what would be the rental from 86 till that period. he has to have it adjudicated. To do that, he first has to satisfy the court that this is the court who can adjudicate that. Secondly, he has to satisfy the court that if he knew as on the date when you withdrew the awarded amount, that the finding of the apex court is that the state was never in wrongful possession. In other words, the possession of the state was governed by a statute. Either the Requisition Act or the Acquisition Act, whatever it is, I was not in wrongful possession from 59. So he has to go and apply for compensation under that statute. It is not a case that he is a ranked trespasser, not paid this amount, therefore ask him to pay. Now, my learned friend is an expert in the field of land laws, Millard. He would be better. That is my assumption. How can he say no? He knows better than me that if the findings staring at his face is that the possession of the state was not wrongful and illegal, which is his case in the plaint, that means it is governed or the possession has been taken pursuant to some law. If whether it's requisition or acquisition, it has not been taken by force. There is no question of any civil remedy being available to him. The statute provides the remedy, he has to go to the remedy. And the thirdly and the most important thing he will have to face is from 86 till 94 today, whether he can claim it looking at the question of limitation staring at his face. But limitation would obviously, Millard, if your lordship...
No party will praise the question of limitation.
That was an ad interim stage, Millard. The final observation doesn't say so. All interim orders, Millard, even I need not say this to your lordship, Millard, all interim orders, all interim directions, Millard, merge with the final order. So my learned friends, counsels, Millard, whoever was there, should have been clear that this final order doesn't cover that interim observation. That was an interim observation. These payments are all interim observations.
There is no such observation in the final order.
Oh. Everything is to be left open to be decided by appropriate proceedings in appropriate forum. And Millard, what
that savings was not there.
Huh?
Savings was not there.
No. We make it clear, generally, Millard, anybody appearing say that we make it clear that these observations or the interim payments, whatever, interim payments they have taken care of. We have taken care of that, they are adjustable. So far as the question of limitation is concerned, Millard, I don't think, Millard, with respect, there is any observation.
So your point is, since rent compensation was received by the plaintiff from 94 to 2007, any other compensation as an interim measure payable under the Supreme Court order is to be refunded.
Yes.
There cannot
All
be double
interim
payment.
payments have to be refunded.
Since there cannot be double payment.
Yes. Now my learned friend will have to now travel the extra mile in terms of the order of the Supreme Court to go before appropriate forum, initiate appropriate proceedings, satisfy the court that he is entitled to further amounts, have an adjudication, and then come. So far as the plaint is concerned, the plaint does not proceed on that basis. The plaint proceeds on the basis very simply that you are in wrongful occupation. Your lordship sees the plaint, Millard, the entirety of the plaint, his cause of action is, Millard, that you are in wrongful occupation from 2000. Kindly, Millard, see the plaint once. Paragraph 20, if I may.
Would you come on some other day?
No. That if your lordship desires me to come on other
No,
day,
may
I'll-
continue otherwise.
it has nothing to do with this. Well, at paragraph 20, my lord, is the crux of his cause of action. In fact, it is his cause of action. Paragraph 20 of the plaint. He's quoted that last paragraph of
Yes.
yes,
Recover rent compensation damages.
and therefore he says that the plaintiff is entitled to claim damages.
For use and occupation since 1st June 1986 till 2007, June 2007.
Yes.
So 988.24 so and so from 1686 to 31st July 2004. Then 18/2004 till 30th June 2007, 70,58,000 something. But why, Mr. Jana, why have you put it this way? Come to para 22.
Of the plaint.
Plaint.
Yes.
1686 to 31st July 2024. You see 988.24, 967. It is okay.
Calculation.
Yes, you have mentioned 988.24, 967. Para 22.
Yes.
Now that is repeated in the particulars 988.24, 967. Now for the second part, 7058 427. Here it is written 1792. It should be typographical error then. You see, you have written here 1st August 2004 till June 30, 2007, aggregating 7058 427. That is in a paragraph.
There must be some typographical.
Yes. Whereas in particular, you have stated it 1792.
Yes.
So this must be typographical error.
Because I think, your lordship's kindly, see the addition.
We have worked out 128.
There must be some mistakes I have to check.
Yes.
We have submitted valuation report. On the basis of valuation report,
Which one is correct?
I have
7058 or 7092? You got my point?
Yes, I have understood.
এটাই করতে হবে
এটা না এখানে
এটা-
58 আর এখানে 92 আছে এই 58 টা এখানে 92 হয়েছে ভাই
Must be some typographical error. Yes.
I will check it later. I will tell you.
Yes, Mr. Vattu.
Now, my third point. While on this calculation, Millard, this calculation is from 86 to
2007.
2007.
30th June 2007.
10 crore 59 and on whatever will so some amount here there 10 crore figure will remain. Sorry. Even if 52, if 92 becomes 58, even then Milord, the 10 crore figure will remain.
Something they will.
Either be 9 point something.
Some deviation might be there, whatever that might be.
Now, the award is subsequent to this suit, filing of the suit. The award is dated 15th November 2007. And my learned friend's plaint is 3rd July 2007. July ki kore hobe? Suit is of 2006. Oh, 2007, sorry. So just 3 months. November, he gets the Supreme Court order. He files a suit in July 2007. And the award comes in November.
Subsequent to institution of the suit.
Where, my lord, a portion of this claim from
What is the award amount?
Awarded amount is 52, 92, 521, 55. That
just a minute. 52,
92, 522.
52 lakh.
Yes.
92,522.
Yes. Which has been withdrawn by my learned friend client in February 2008 unconditionally. So, my lord, during the continuance of the suit, my learned friend knew that a portion of this claim, portion of the period for which he is claimed, has already been adjudicated upon. Has already been adjudicated. He is only left with 86 to 90, 94. Eight years. He is left with approximately 8 years. Now, while calculating this, my learned friend has set off 1 crore 28 lakhs 200.
1 crore?
28 lakhs
How?
200. What he has done, my lord, is after calculating the entire amount, which according to him is the valuer's report and whatever, he has taken into account the ad hoc payments that I have made. That is that is the subject matter of my counterclaim. So 1 crore 28 lakh 2,000, which was paid to him, particulars which your lordship will find in paragraph 23 of my written statement. Kindly take this side by side, my lord, written statement and plaint.
In your paragraph?
Paragraph 23. So he has given me credit for this. So in other words, according to his own calculation, his own case, 1 crore 28 lakhs was an interim payment. It was not a final payment. He has not taken that to be final. He has not adjusted it. On the contrary, according to him, he is entitled to a much larger sum of 10 lakhs. And if you give me 10 lakhs, that 1 crore 28 lakhs, which is supposed to be refunded to you, I'm refunding it to you. So my case that I'm entitled to refund of 1 crore 28 lakhs on principle is admitted. Because his plaint itself shows that he is giving me credit for that.
Where it is there?
Will you kindly see the calculation? He has made 10 crore 59. Just below that, less amount received 1 crore 28. So, my lord, from his entire claim, he is deducting the entire payment of 1,28,00,000, which I am claiming from him under paragraph 23 of my written statement. So there is no dispute as regards the quantum of payment.
So your point, what comes to, it seems to me, is that on receiving the award amount, rest of the claim remains forfeited.
My point is slightly different with respect, Vinod. What I'm trying to say is in the same lines, is that you had set up a claim of 10 crores. You said, I have received 1,28,00,000. I'm entitled to 10 crores. You have given me interim payments. So I'm giving it back to you. Deducting that 9,30,00,000 is my payment.
Out of 9,38,00,000?
Out of 9,38,00,000, which he has said.
Once the award amount is received,
once the amount award is
this
received,
amount stands forfeited.
so 9,38,00,000 he cannot receive. He can only receive the amount which he has accepted as award. And he is not saying that this is in partial satisfaction of my claim, because the period.
And there was no subsequent amendment of the plaint.
No. So the period for which the award covers, Millard, is the period which he has claimed. So for the period today, Millard, for the period 94 to 2007, he cannot claim a single paisa more than 1 crore, than 52, 59, whatever the awarded amount has been.
50 to 92.
Because there is no challenge to the award. And there is an unconditional acceptance. So if 52, so Millard, now kindly see, if deducting 10 crore 59, if we write here 52 such and such, then Millard, he has received more.
Admittedly, this is 128.
So therefore, till such time he proves in whatever, if my first argument is right, that he has to go before an appropriate forum to prove, this 1,28,00,000 I don't have to prove, because he is himself giving me credit for this. So by operation of law, Millard, set off, Millard, is always a dangerous defense, because if I am setting it off, that means I am giving you the credit that you are entitled to receive this amount. But if my parent claim fails, then that admission goes. With that admission, that money comes to me. So in my respectful submission, out of my counterclaim of 1,28,00,000, that 29,15,017, 1,28,200 is already admitted by the defendant.
All right.
So I am entitled, my clients are entitled to a decree of 1,28,200 on 20,000 on.
Would you like to file any additional notes of argument?
That this portion is not there. This counterclaim portion is not covered.
Heard Mr. Dr. the learned senior counsel for what state? What defendants?
But defendants, because
Who is Tunkai India?
আমরা 20
What the defendant?
Tulka na মানে the Dawlat Singh Surana is the 20. Oh, company na.
Liberty is given to file notes of argument before vacation. I'm fixing a date before vacation. Sixteenth May. देखे ना 16th May for further argument, so that I can utilize the vacation.
I have completed
On the next day, shall I make submission?
Yes. I have completed my submission.
You will bring his notes of argument, additional notes of argument, or if anything to argue. If you want another date, that I can fix.
Otherwise, I have to start argument. Otherwise, I will make my submission.
No, he will finish his argument and file notes of argument
On that day.
on that day.
After
You finish your argument.
on the day, shall I start or
Better.
shall I start? Very good. Your lordship is fixing it on
16th May.
Friday. Very good.
Because I want to study it throughout the vacation.
Yes, I can start. I can just in 2 minutes I can outline the submissions. But here and now your lordship has passed the order, no problem. Remember, main thrust of argument is this. According to the decision of the division.
Let me go through your notes of argument, both of your notes of argument.
Just I am pointing out what I want to submit. What is his submission. You want to submit
we are entitled to get compensation for possession. But their possession because of vesting is not illegal. But he has admitted that we are entitled to get possession from 86 to 95 according to his own submission for the 8 years or like that. This is one submission. Second aspect is this, my learned friend submission is this, that because of the award passed by the land acquisition collector, everything is covered by the award. Whatever compensation is to be made, that is to be made to the reference code or whatever like that. And third submission, always he tried to say that the award has been accepted without challenge. That is not the case, because no documents has come and it is not necessary to come also. We have filed application for reference challenging the award that is pending before the reference court. That is pending before the reference court. If your lordship so wants the document, I buy. But
That's up to you. Why should I want?
No, I do not want to propose also file those documents. Whatever the consequences, whether my submission is this, no part of my claim is covered by the award.
All right.
Under the land acquisition. That I will submit.
Can you give me a copy of the reference? I would like to see it once. I just want to
Because
see.
unless that is an evidence, I will not take into consideration.
Nobody can rely upon it. We have
No,
filed reference.
unless that is in evidence, this is
Yes,
suit.
nothing-
I cannot take into consideration.
That's why. That's why. My learned friend has said rightly whether
Because if you see it, Mr. Dotto, if you see it, you'll be influenced. And I will not accept that part of argument.
But just I am making clear. to
Because
Mr.
obviously
Datto.
that argument will be on the basis of some document which is not in the exhibit.
No,
That I
yes.
cannot hear.
Only thing I am making explaining to Mr. Datto that whatever may be the, even if we submit, even if we accept that no challenge has been awarded, but the question would be whether the award covers the claim made in the suit. That is independent. That is independent. If I can show to your lordships, then none of the part of my claim is covered by the award declared.
Come on.
Whether I am accepted, my lord, without protest or with protest, that doesn't make any difference. That doesn't make any difference.
There is no prejudice to your right.
Yes. We have, I am just out of court, I am telling, we have filed application for reference, challenge the award, that is there. But that is no, that will not be.
This court will not take into consideration because that is not in the
That is not
evidence.
issue. None of the claim, no part of my claim will be covered by the award.
all
That I will decide, that I will explain to your lordship under the law, and other points which have been also taken by Mr. Dotto. So certainly I will try to explain before your lordship in my own way to assist your lordship.
I have consumed your time, whole time.
And Millard, I have realized this.
আপনি যদি
Millard,
বলতে চান বলতে পারেন, written হওয়ার পর I will not oppose.
আচ্ছা, বলা হয়। I have realized that Millard, doing it in one go, Millard, is also helpful for us also. Otherwise, every time it
Every time you will come.
will have to again start afresh, waste the court's time or keep everything. And more important, I'll have to get ready again from the because I keep forgetting.
May I request one thing to Mr. Dotto, যে আপনি যখন additional লোকটা দেবেন ওটাকে যদি একটু আগে আমাকে দিতেন, তাহলে আমাকে একটু advance copy পাঠিয়ে দেবেন আমার সার্টিফিকেটের কাছে।
Item 19.
My lord, I am appearing on behalf of the plaintiff. Their
Where is the
witness was
witness?
So Lordship will recall Mr.
Yes.
Deb had mentioned this matter because due to
Mr.
his
Dev is
unable
my
to
leader in this matter, my lord. He is not unavailable. So, in light of the same, my lord, we had mentioned that he, if a date can be fixed for the cross-examination. So, it's not their fault per se.
So Mr. Deb had mentioned, we had concurred that your Lordship had directed that it
My lord,
Which date? After vacation?
as what my
After vacation. Come after vacation.
would any day before vacation if your Lordship.
Other matters are there. I have to keep.
576, the other matter, that preliminary.
Five?
576, the other connected matter.
What is the name? That date?
So that is on probably 7th or 8th.
এই সপ্তাহে আছে?
Sometime before the vacation, Lordship.
8th. It's on 8th.
Lordship fixes this matter one day before the vacation, Lordship.
Or after the vacation, as my lord pleases. So,
21st May.
Very well. Great.
as my lord.
The suit will appear in the list for witness action on 21st May.
Grateful.
Item 20. Item number 20.
Is to allow the amendment application.
It is to be carried out.
It has been carried out, Your Lordship. Only the copy has to be served.
Let it appear after vacation so that we can serve and come, Your Lordship.
With for the defendant.
Lordship, he was not appearing. In spite of the service, he was not. So
The learned counsel for the plaintiff submitted that amendments have been carried out and the amended copy of plaint is yet to be served upon the defendant.
Lordship.
Defendant.
Defendant, Your Lordship.
Defendant. The suit will appear in the list on 24th June. Amended copy of plaint shall be served in the meantime.
Keep your
21.
Your Lordship, I am appearing on behalf of the petitioner. Somridha Sen is leading me, Your Lordship. Your Lordship.
Witness, where is the witness?
Yes, Your Lordship. You will be pursuant to the order.
Witness is there or not?
No, Your Lordship. I am just addressing Your Lordship pursuant to the order passed by Justice Somen Sen on 27th October 2017, Your Lordship. Kindly see the order, Your Lordship. The attesting witness have filed letters indicating their stand with regard to the mutual will, Your Lordship. But the letters are not in our custody right now. The letters
Witness is to be appear here and depose. That's all.
Yes, Your Lordship. Then kindly pass one order, Your Lordship.
Witness action is deferred to 18 June.
Item 22.
Witness is there. Who is your other side? You are defendant.
Yes.
He is PW.
Yes, plaintiff's witness.
Chief.
Chief.
Where is your witness?
No, witnesses.
First time.
हम धर्म से कह रहे हैं इस मुकदमे में गवाही के तौर पर हम जो कुछ भी बोलेंगे सच बोलेंगे, सच के सिवा झूठ नहीं बोलेंगे और कुछ नहीं छुपाएंगे। रमाकांत कंकानी। रमाकांत कंकानी। युगल किशोर काकानी। 49 सेंट सर्विस। हाँ, हावड़ा शिवपुर। पूरा फुल एड्रेस या विवेक बिहार फेज 3 493 by C by विवेक बिहार फेज 3 493 by C by A GT Road, C by A GT Road South, शिवपुर हावड़ा 7111-102।
May I start? Mr. Kankani, how are you involved in the present suit?
मैं इस कंपनी का एक डायरेक्टर
Do you understand Bengali?
Yeah.
Don't say yeah. Say yes.
Yeah,
Don't say
yes.
in court. Never say yeah.
I'm the director of the company. Which company?
plaintiff company.
I'm the director of the company.
Have you been authorized by the plaintiff company
Yes.
to adduce evidence in this suit?
Yes.
Have you disclosed any document in support of such authorization?
Power of attorney and board of resolutions.
I am showing you a document, a copy whereof is appearing at pages 14 to 20 of the judge's brief of documents. Can you indicate what is this document?
This is power of attorney given by the company to me For the suit. For this suit.
What is the date of this document?
5th August, date 5th August 2021.
Please come to internal page 6 of this document and tell the honorable court whether you can identify any signature on this page.
The signature of Director Sri Sankarlal Kedia.
Signature of Director Mr. Shankarlal Kedia.
Is there any other signature appearing on that page?
And second one is my signature accepted by me. This power of attorney.
The second one is my signature. I signed on the document. Power of attorney. To accept the power of attorney.
Apart from your signature and the signature of Mr. Shankarlal Kedia,
Yeah.
do you find any other signature on this page?
There is a signature of a notarized Mr. P.K. Datta, identified Mr. Tina Das, advocate.
थोड़ा slow बोलिए, otherwise it won't go. थोड़ा slow बोलिए.
There is a signature of Mr. P.K. Datta. Identified by Tina Das.
How can you identify the signature of Mr. Shankarlal Kedia?
I am showing their signature in many documents in day-to-day work. And
I have seen him signing many documents in my present in the day-to-day work of official capacity. Official capacity.
How can you identify the signature of Mr. P.K. Datta and Tina Das?
हम दोनों ने इनका सिग्नेचर नोटराइज करवाया है और इनका सिग्नेचर मैंने पावर ऑफ अटॉर्नी में देखा.
But I have filed an application for this purpose. Lordship had dismissed my application. Lordship had been pleased to reject my application on the context that the filing date of the suit is prior to the notification date. Lordship has also recorded. Yes, I applied for transfer.
My lord has already rejected that. Will let us.
On the ground, the notification date is subsequent.
And this issue has already received the consideration of a coordinate bench, my lord. Coordinate bench held that the suit is maintained.
Yes, I know, and trial has started. Like I'm still making the same prayer. According to me, I am a bank, NBFC. My business is to lend money.
No, there's much to be said about this.
So I'm not getting into the argument right now. We are in trial. Yes.
That's why
I asked for a recall. Lordship said no. Lordship has recorded it. Lordship has recorded. Lordship has given reasons. That is the reason. Lordship in the last line. Lordship also recorded that the date of filing of the suit is consequent. That part is there. Yes. I said I'll be prejudiced. Lordship scolded me saying that look at the notification date and look at your filing date. And I will not agreed to it. I had to accept it. Lordship was correct on that. I won't be prejudiced if it is transferred even at the later stage because it's a pending suit.
My lord, we will address your lordship at the appropriate occasion again on this issue.
But not my prayer. Lordship would take the application if Lordship, that is on record.
In that order, but just shut up.
Yes, 2nd March 2022.
That order was also a consent order. We filed an application. They said no, not necessary to be transferred. We said very well. If they are not willing, not necessary. So I withdrew my consent and filed this application. Lordship.
No, my lord, kindly allow me to make my submissions on this then, my lord. Here, kindly allow. My lord will also appreciate, my lord. Here, coordinate bench has passed an order. Allow me one moment, my lord. Today I am not prepared to address your lordship on this issue.
How much did they say?
Then allow me to come back because, my lord, today I was prepared for witnesses. This is already, my lord, received your lordship's consideration. We will come and address your lordship again. Kindly allow me to come.
So should I continue with the evidence? I have no problem.
Yes. Very well.
Only thing is that in a commercial suit, had it been
There is the order of coordinate bench.
I sought for recall of that order. Not lordship cannot. I have to probably approach.
You have to approach.
But that judge is no more. That Honorable Justice Sharaf is no more there in this court.
Then some bench must be designated.
Yes, for those matters.
Yes.
Absolutely correct. But lordship can suo moto now that the lordship. Yes. Without recall. That's correct.
How can you identify the signature of Mr. T.K. Datta and Tina? Tina, ये पीके दत्ता एंड टीना दास का नोटराइज से ही सिग्नेचर वेरीफाई किए उसमें ठीक है
आप कैसे आइडेंटिफाई कर सकते हैं कि पीके दास का और दत्ता का और टीना दास का ही सिग्नेचर है? आप कैसे आइडेंटिफाई?
हम लोग उनका नोटराइज करवाने गए थे तो वहां पर पीके दत्ता ने मेरे सामने इसको सिग्नेचर किया है और इसको आइडेंटिफाई टीना दास ने किया है
Of mine and after identified the method.
What do you say about the contents of this document?
इसके बारे में क्या पता?
इसके
ये
यस
Where is the original of this document?
this is the original.
That may the power of attorney dated 5th August 2000.
With signatures.
Yes. May exhibit it. ওটা একটু হাতে রাখবে ওটা একটু হাতে রাখবে ওটা লাস্ট পেজটা একবার আসবে হ্যাঁ বলে
Encircle the signatures.
আগের পাতা ওইগুলো সই করুন with a exhibit all these should be separately exhibited because the number poll A1 A2 the series along with annexure along with signatures well last part that now wait. I am showing you the document appearing at page 20 of the judge's brief of document. Please tell my lord what is this document?
This is the board regulations. This is the board regulation authorizing me for execute the necessary documents and papers for for this case for signing the power given to me.
Please read this document once again and tell my lord what is the specific purpose for execution of this document.
इसकी क्या पर्पस थी किया गया
ये डॉक्यूमेंट ये ऋतिका गृह निर्माण प्राइवेट लिमिटेड के साथ ऑनरेबल हाई कोर्ट में केस के लिए कोई भी पेपर एंड डॉक्यूमेंट साइन करने के लिए मुझे ऑथराइज किया गया है, वकालतनामा एटसेट्रा एनी पेपर्स।
sign on the Vakalatnama, plaint, petition, application, complaint, and reports on behalf of the company.
Have you been authorized to adduce evidence before this honorable court also on the basis of this document?
This is the authorization दिया गया इस केस में.
हाँ,
Can you identify any signature on this document?
signature of required.
इसमें हमारे डायरेक्टर से शंकरलाल जी केडिया का सिग्नेचर है।
Yes, there is signature of our Mr. Shankar.
How can you identify his signature?
Yes, there is
हमारे ये डे टू डे वर्क में इनके बहुत से पेपर एंड डॉक्यूमेंट साइन है ऐसे।
signing official documents.
What do you say about the contents of this document?
रिकॉर्ड पक्का क्या हुआ है?
सही है।
Where is the original of this document?
This is all.
But may the board resolution appearing at page 20 of the judge's brief, let be marked as exhibit, should be B.
That is not the original.
That is the original. It is the original.
This must be marked.
Yes, that.
Yes.
ওই পেজ ওটা আগেরটা 6 to 19 14 হ্যাঁ প্রথম থেকে এ হবে ওই পেজ 14 to 19 ওটা শুধু বি হবে সিগনেচারটা যদি জজ সাহেব বলেন
B by 1.
এই ডকুমেন্টটা ভুলেছে কি এটা বলা হয়েছে প্রশ্ন করে দিতে এটা হয়ে গেল
That's not what Where is that on his chair?
আমি দেখলাম তো এই দেখছেন
একবার এই পাতাটা হলে আলাদা করে দেখান এই পাতাটা পিস পেজ আলাদা করে
পার্ট অফ দিস পার্ট
কান গো পার্ট না এটা তো আলাদা আলাদা করে যাচ্ছে এক্সিবিট এ হয়েছে বি হলে সি যাচ্ছে
These are letters of authorities and that is death certificate.
Yes,
So it should be different.
Lord, this death certificate is made annexure to this power of attorney.
But
This
you have
is
to
second power of attorney. First power of attorney was given in the name of.
So get the explanation. Get explanation of this death certificate.
Look, it's original this document has to be proved separately. Documents has to be proved.
Why the document is relevant? Death certificate is relevant. Get the explanation.
That I will get.
Then it will be marked.
Because the originally it was given to.
All right, I got it. Let him explain.
Now he has been given. So power his death.
Why this death certificate is here? Explain.
Mr. Abhay Gandhi, the director of the company, is expired.
Show it to him.
Showing death certificate of showing a death certificate. Showing a death certificate.
Abhay Gandhi.
So it is annexure to power of attorney.
এরকম করে দিন এরকম করে দিন showing annexure A, showing annexure A to the exhibit A. এভাবে একটা question shown annexure A to the exhibit A. Please tell my lord, what is this document?
Death certificate of
Can you tell my lord what was the date of death of Mr. Abhay Gandhi?
2020 5/4/2020 5/4/2020
Who has issued this document?
विधाननगर म्युनिसिपल कॉर्पोरेशन ने
What do you say about the contents of this document?
ये सही है.
Where is the original of this document?
ओरिजिनल डॉक्यूमेंट जो है वो ये लेट अभय गांधी जी के वाइफ के पास में है.
How have you obtained this document?
उनसे इनके डेथ होने के बाद इनकी वाइफ से ये मंगवाएगा.
May this document be marked as an exhibit.
C.
টেবিল করে দেবেন, খুলে গেছে. I am showing you a document appearing at pages 6 to 12 of the 6 to 11 of the judge's brief of document. Please tell my lord, what is this document?
Where are the originals?
That is what I have handed over.
ये पावर ऑफ अटॉर्नी है जो श्री अभय गांधी जी को इस केस के लिए दी गई थी.
What is the date of this document?
24 जुलाई 2018.
Please come to the internal page 5 of this document and tell my lord whether you can find any signature on this document, on this page.
इसमें मिस्टर शंकरलाल जी केडिया डायरेक्टर का सिग्नेचर है.
Is there any other signature appearing on that page?
हाँ, इसमें नोटराइज मिस्टर पी.के. दत्ता और एडवोकेट उत्पल सेन चौधरी जी का भी.
How can you identify the signature of Mr. Shankarlal Kedia?
ये हमारे कंपनी के डायरेक्टर है और डे टू डे के ऑफिशियल डे टू डे पेपर्स एंड डॉक्यूमेंट्स पर इनका सिग्नेचर किया हुआ है उससे.
The director of our company, and I have seen him signing. So that's good. This much today. One witness is sitting there.
Let this be exhibited. Two more questions I'll exhibit. What do you say about the contents of this document?
सभी सही है और ओरिजिनल.
Where is the original of this document? May this be exhibit D, below. Kindly encircle the signature of Mr. Shankarlal Kedia appearing at internal page 5 of this document in blue ink. Blue pencil. May the signature be marked as exhibit D1 and the document be marked as exhibit D. But I'll come back on any date, Lordship.
After vacation.
Conclude হয়নি.
Continuing on the next day, but in the judge's piece of documents, what has been disclosed by my learned friend, there are some hierarchy because the documents which have been disclosed by the plaintiff has been treated to be as the disclosed by the defendant's document. But the defendant's document which have been disclosed by the defense statement as well as in the list of documents that has not been given to the in the judge's brief of document. That has to be rectified, your lordship. Because
that you have to check.
The letters which has been given by the defendant on their letter A has been treated as defendant's document. But those that documents are not of the defendant's document, that are of the plaintiff's document.
That you come on the next day.
But who is disclosing? But
come on the next day. Who are relying on those documents?
He's relying. I'm not relying.
I'm not denying. You are relying in your claim.
He by a letter. No. He watch. No. That
Come on the next day. Check it. Come on the
I
next
will
day.
check it. I will check it.
PW1 is partly examined in chief. Further examination is deferred to June 16th.
And in the meantime, that issue of commercial suit that Lordship has observed.
This will be a commercial suit, no doubt. I did not pass order because a coordinate bench order was there. Or I can do one thing after trial, after evidence is over, then I can transfer. That was my order.
Yes, that is what the Lordship intended. That's told me on the
Before hearing argument, I will transfer. If the determination remains with me.
If it's a commercial, will be faster. We'll do it in affidavit.
Problem is this.
So many
if
questions are not.
determination changes. Problem is this. You know, we believe and we rely and we say whatever your lordship. But if determination is changes, then we will make trouble. So your
now it's
lordship may
witness
kindly
action.
record it that after evidence, all further necessary order with regard to
Already been recorded in your lordship.
After trial, before argument, if the determination remains, I will transfer it.
my lord.
23. Item number 16th
Solo.
16th.
Oblige me, lord.
I am for the plaintiff. I am appearing on behalf of the defendant. I am led by Mr. Jayant Toshenko. Your lordship.
If is over.
No, your lordship. Our
Yes.
witness was in the box.
Mr. Doshi.
They said they had 2 or 3 more questions to close.
Yes, your lordship. Essentially, what is left is the proving the section 65B certificate.
Is it there?
Yes.
Deepak Harshad Rai Doshi.
We have received an advance copy.
Mr. Doshi, kindly take a look at this document and please tell my lord what is this document about.
It's the affidavit affirmed by me.
Why have you affirmed this affidavit?
We filed and affirmed this affidavit to prove the electronic documents and the printout of the photographs on behalf of the defendant.
Who signed this document?
So signed by me and the commissioners, Your Lord.
Is it your signature?
That's my signature, Your Lord.
Encircle your signature. Blue. The document is marked as exhibit.
10.
Why 10? He is defendant or plaintiff.
Defendant.
Exhibit 10, signature 10 by 1.
10 by 8.
10 by 8. The lordship here.
Cross.
Is the Faraday Club, in your opinion, a distinguished institution?
It is a distinguished institution for sure.
Who is Sanish Megon?
Who is?
Who is Sanish Megon?
Spelling ka diya na.
Sanish Megon, your lord, is a member of the club and currently holds the position of the president.
What is the spelling?
Lord, we'll give the spelling to the office. Has Mr. Megon ever faced any disciplinary action in the club?
Witness remained silent for some time.
My lord, I'm just trying to recollect. It's been many years. There was some incident, but I cannot remember the details.
There was some incident, but I cannot.
Is it true that Mr. Megon,
MEGAN,
MEGON, SANI,
spelling টা দেখে নাও, spelling টা দেখে লিখবে।
দাদা এটা দেখে নিন।
It is true that Mr. Sanish Megon destitute.
Is it true that Mr. Megon had a quarrel with Mrs. Megon in the club and also chased her into the ladies' restroom?
I am not aware.
Has Mr. Megon ever been suspended?
My lord, I do not recollect.
Is it possible for you to check on the disciplinary action taken, or is it possible for you to check on the records of any disciplinary proceedings against Mr. Megon and get back to the Honorable Court?
Yes, my lord, that would be possible.
Please do it on the next day. Where were you when the alleged incident took place, about which you have deposed in your evidence?
I was not in the club, my lord, as I have deposed earlier.
Question repeat. Please specify where were you when the alleged incident took place?
I was home, my lord.
When did you first learn about the alleged incident?
My lord, I first learnt of the incident on the 25th of December.
What time?
2019.
At what time?
Sometime in the day.
What was your first decision taken as the president of the club when you learnt about this alleged incident?
There was no immediate decision, my lord. We heard of the incident. We heard of the ruckus. I heard of the ruckus, my lord, which had happened in the club the previous night.
Which has happened the previous night.
I remember there was a lot of discontentment amongst the members. There was obviously a lot of discussion that such an act of indiscipline had happened within the club premises. I'm sorry.
Discontentment among the
Amongst the members, because Christmas Day is a day of celebration in the club, and we have the children's carnival. So there was a lot of presence of members, and this was a talking point. This is what I recollect from memory.
Read out. কি লিখেছো একটু পড়ে শুনিয়ে দাও।
there was no immediate decision. We heard of the alleged incident which was happened in the club on the previous night. I remember there was a lot of discontentment amongst the members because Christmas Day is a celebration day and we have
because of the act of indiscipline within the club premises.
Because the incident happened on a Christmas Eve.
Yes, my lord.
Incident happened on the Christmas Eve.
And lot of presences were there.
And we have the children's carnival, so there was a lot of presence of members, and this was the talking point. This is what I recollect from the memory.
Who are these aggrieved members to whom you have referred in your previous answer?
Permanent members, basically the membership body of the Saturday club.
What do you mean by membership body? Are you referring to the general committee of the club?
No, my lord, I'm referring to the members in general.
Is there any complaint from any member in general addressed to the club about this alleged incident?
In verbal form, my lord.
Verbal form.
So I take it that there is nothing in writing from even one general member.
No, my lord.
Was Mr. Magon a part of that meeting where the decision to suspend the plaintiffs was taken?
Yes, my lord. Mr. Megan was a member of the general committee.
Lord, may I stop here? Because he has to produce certain things on the next day.
DW1 is examined in chief in full and partly cross-examined. Further cross-examination is deferred to June.
As per Lordship's convenience, my lord.
12 June. 12 June is okay?
Yes, my lord.
Grateful, my lord.